Yes, please. Item number one.
Yes, I'm right. My lord, may kindly peruse the last order, my lord.
What is this PIL? How can you file a PIL on that?
The
These are topics to be discussed in the assembly, not in the court.
already, my lord, there is an enactment, my lord. Act is there, my lord. The issue, my lord, discussed in the assembly, my lord, thereafter act has been enacted, my lord.
Yes, so why are you filing PIL for that?
My lord, my humble
The writ court cannot give a direction to frame rules. The relief you are asking for cannot be given by the writ court. Why are you pursuing this unnecessarily? This court cannot direct the government to frame rules.
my humble understanding, my lord, already act is there, my lord. Act is there, my lord. Now that is the command of the legislation, my lord. Now, command of the legislation said, my lord, executive need to frame a rule, my lord.
Right.
No,
Rules should be framed,
my lord.
but the court cannot issue amendments to the legislature to frame rules.
But, I
That's the
believe, my lord,
problem.
if my lord, executive, my lord, if executive, my lord, is not doing his duty under the law, my lord, surely, my lord, my humble understanding, my lord, read court can direct, my lord.
These are statutory rules. These are statutory rules. This is not the executive function. This is legislative function.
No, my lord, it is.
Let us see. Let us see. Where is section 8?
The page number 23, my lord, is the command, my lord, or 8, my lord. The government, my lord. The government may make rule, my lord. This is the government, my humble, this is
right. So this is delegated legislation.
Government, man.
What do you have to say?
My lord, so far, my lord, this paragraph 8 is concerned, man. It says, man, government may, my lord. So when you say government, obviously, my lord, is the policy making body, my lord. My lord, in our paragraph 7 of the affidavit, my lord, this is the sensitive issue, my lord. And there are not, as you know, my lord, there are 26 major tribes. So, my lord, AG in effect also, my lord. So all the stakeholders has to be taken into, my lord. It's not that
It's not a subject matter of a PIL.
Then I may be try to.
Actually, it's becoming the PIL kingdom of India.
my lord,
PIL
yes. In every issue, my lord, you'll also find one PL will be there.
My lord, then my lord, I may be allowed to, my lord, try to satisfy my lord that, my lord, this is case of PL, my lord. Now, my lord will kindly turn to page number 25, my lord. Oh, my lord. Pass before, my lord, my humble understanding, this act, my lord. This act has two broad objectives, my lord. Now, past objective, main objective of this act, my lord, to, my lord, for habit, my lord, conversion, my lord. Now, second, my lord, is to punish, my lord, any, my lord, a contravention of this act, my lord. Now, my lord, main objective, my lord, was to protect the, my lord.
So you are arguing for disposal.
My lord, last occasion, my lord, has some pass. That's why I
Last occasion, what?
direct or some pass, some order, my lord.
So are you proposing to frame any rules?
My lord,
To order dated 10/1/2024.
My lord, in our affidavit, paragraph 7, my lord, we have said so, my lord.
Yes.
After that,
No, my lord.
No,
Affidavit
not
is
after
filed
that,
with-
not after that, not after that.
your affidavit is of 2000,
Yes.
June 23,
Yes,
10/1/2024.
yes, my lord.
And paragraph 10, you said it's still, it's under active consideration.
Paragraph 7, yes, my lord, we have said so, my lord.
Paragraph 10,
Paragraph 7, paragraph 10, yes, absolutely right.
active consideration for years to come.
My lord, these are the sensitive issue, my lord, because all the stakeholders have to be taken into confidence, my lord. As I've said, my lord, there are 26 major tribes. And engineers face, my lord, is varies from tribe to tribe, slightly, my lord.
So what is your submission today?
But a submission, my lord,
You want a final order today?
the lordship can, if your lordship wish, desires, it can be disposed of. My lord, the
No,
affidavit filed
there
with
is an
government.
order of the court to obtain instruction. What
My
is the
lord,
instruction?
I'm sorry, my lord, that part, my lord, yes. But what exactly is saying, my lord, is already there in the act itself, my lord. What will happen if there is, my lord?
We'll adjourn it. He doesn't have the instruction.
Well,
Let him obtain the instruction. Mr. Elpa, Council for the petition. Also for Mr. Vaishnavam, learned additional AG, appearing for the state, submit that. Due to inadvertent date 10/1/2024 has escaped his attention, as a result of which the updated instruction would not be of by whom. Missed. Therefore, prays for 6 to obtain updated instruction in terms of the order dated 10/1/2024. Prayer allowed, list the matter accordingly. You obtain it.
yes, my lord. Now I have this copy. Actually, registry is supposed to submit. Anyway, my lord, I got the copy.
Did you
It's can
obtain
be
it?
communicated.
Yes, this is a sensitive issue.
Yes.
Obviously.
Technically, no direction can be issued to frame rules. It cannot be done. Yes.
Item number 2 and 3.
Madam Your Lordships. Madam Your Lordships. Am I audible, my lord? Am I audible, my lord? Am I audible, my lord?
Yes, please go ahead, Mr. Majumdar.
I'm sorry, madam. When the first time was going on, everything was okay. Suddenly, when my matter started, this problem arose.
Yes.
Anyway, madam,
Yes.
this is a very unfortunate case where the respondent, who is the petitioner before the honorable single judge, madam, who is working as a mining assistant mining development officer in the Department of Mining and Geology of under the government of Arunachal Pradesh. Madam, in order to contest the ensuing General Assembly election, he submitted his resignation on 8th of September 2023. Since then, my lord, the government is dilly-dallying the matter, and ultimately, when the government did not do anything, I had to approach this honorable court by filing a writ petition. Now, the writ petition was allowed. If your lordship kindly turns to page, my lord, page 44, my lord. By a very short order, this honorable court disposed of the writ petition, allowing the prayer of the writ petition. Lordship will find Page 11. My lord, Lordship will kindly turn to page 11 of the writ appeal, my lord.
Yes.
My lord, I'm sorry, my lord, I'm taking your lordship to page 16. First page 15, my lord. The only paragraph 12 will suggest on what basis the honorable single judge allowed the writ petition. On a specific query by this court, the learned state council, however, lordship has got, my lord. Paragraph 12.
Yes.
On a specific query by this court, the learned state council, however, submits that he does not have any instructions as to whether there is any departmental proceeding pending or initiated against the petitioner. The act of resignation by an employee may not be one-way traffic, and therefore the rules governing the field has laid down a certain period of such acceptance before which the employer would be in a position to reject such offer resignation, which in this case doesn't appear to have been done. Then, my lord, lordship will kindly turn to page 16, paragraph 12. The offer of resignation by the petitioner did not stipulate any future date from which such resignation was to be given effect. The law is well settled in this regard by the decision mentioned above, that in the event of employee doesn't stipulate any future date for giving effect to such resignation, the employer may not have the discretion to have another date. As mentioned above, there is no express denial of the request for the resignation. In that view, the matter, the deemed acceptance which has been held as above would take effect from the date of communication of the resignation, that is 8/9/2023. But the state is in no way aggrieved by this order, and the state has filed an appeal and obtained a stay in order to prevent me from participating in the ensuing General Assembly election, my lord. Lordship will kindly have a look at the grounds taken in the appeal. Just on certain flimsy grounds, they have filed the appeal and obtained the stay. My lord, from today, the nomination paper is accepted, and the filing of nomination paper has been opened, and I am unable to file the nomination paper because of the stay order, my lord. Lordship will kindly see some grounds they have taken at page 7.
Which party? Which party? Your client
Party-
wants to contest election from which party?
That party, I am not very sure, my lord. Maybe independent also. Possibly independent, my lord. Well, absolutely no ground. Lordship will kindly permit me to take to the two office memorandums which are relevant for the purpose of deciding as to whether the person's resignation should be accepted or not. May I take your lordship first to page 55 of the memo of appeal, my lord. These are the two office memorandum of the government of Arunachal Pradesh, my lord. Page 55, my lord.
Yes.
The third paragraph, which is serial number 2 from top, my lord. It is Ever Lordship's government, page 55.
Yes.
Well, he is contesting as an independent candidate. I have confirmed that. Serial number 2 at page 55 says, it is not in the interest of government to retain any unwilling government servant in service. The general rule, therefore, is that a resignation of a government servant from service should be accepted, except in the circumstances indicated below. 1. Where the government servant concerned is engaged on work of importance and it would take time to make alternative arrangements for filing the post. The resignation should not be accepted straightway, but only when alternative arrangements for filing the post have been made. This is not there in my case, my lord. This has been held by the honorable single judge. Now, lordship will kindly turn to the next page 60, my lord. There is another office memorandum of 94. My lord, this is an office memorandum of 31st of May 1994.
Yes.
Subject acceptance of resignation procedure in respect thereof. The undersigned is directed to say that the questions have been raised from time to time regarding the requirement of obtaining vigilance clearance in respect of an official before acceptance of resignation submitted by him from government service. The matter has been carefully examined and the position is clarified in the following paragraphs. 1. Under existing instructions, it is provided that where a government servant who is under suspension submits his resignation, the competent authority should examine which, with reference to the merit of the disciplinary cases pending against the government summit, etc. And now we can see because he is not under suspension, admitted. Next is, my lord, number 2, Roman 2. Existing instructions on the subject of acceptance of resignation of officials against whom inquiry or investigation is pending. Against me, my lord, till now there is no disciplinary proceeding or any other criminal investigation is pending against me. This is also an admitted fact. Now this serial number 3, my lord, which is of some relevance, page 61, my lord. In recent times, cases have come to notice where resignation of officials not falling in the 2 categories mentioned in the preceding paragraph have been accepted without insisting on vigilance clearance, and subsequently it came to light that the said official, while in service, had been involved in serious irregularities. In view of this, it has now been decided that in all cases of acceptance of resignation, the competent authority shall insist as a mandatory measure on prior vigilance clearance before taking the decision of the request for resignation. When an authority refers a case for vigilance clearance, the authority competent to accord vigilance clearance should ensure expeditious consideration of the request. Now, in this case, what has happened, my lord? Earlier, an NOC was granted. NOC was granted to the petitioner, my lord. And, my lord, this NOC was abruptly, NOC was granted, my lord, on 5th of September 2023. Lordship may kindly take the note of the date, my lord. 5th of September 2023, NOC was granted on 5/9/2023, my lord. And on 18th of September 2023, based on some purported objection by a private party against me, by a
Mr.
private party,
Majumdar, your voice is breaking, so we hope we are understanding your case.
my lord,
We can't guarantee you.
my lord,
Sometimes
I'll be very slow and let us hope.
part of it is audible,
My lord,
but hope we are being able to understand your case.
my lord,
If
my lord.
we don't understand your case, we can't help it. Yes,
My lord,
please carry on.
I'll try. I'll let us hope, my lord. On the 5th of September 2023, the NOC was granted. 18th of September 2023, my lord, based on some purported report made by the circle officer and behind my back without any intimation to me, the NOC was cancelled. Then I approached this honorable court in WPC number 489 of 2023.
Yes.
My lord, then earlier I approached this honorable court challenging that cancellation of NOC, and this honorable court on 7th of December 2023, page 44, Lordship may kindly see the order passed earlier, my lord. Starts from page.
So you don't have any objection. You have not filed any.
Lawsuit notice is not yet issued in IA lawsuit.
Today is the first listing.
It was listed, but notice was not issued lawsuit.
My lord,
And therefore, lawsuit, if IA is to be taken up first lawsuit, then I may be given a short time to file objection lawsuit.
my lord,
And if interim matter is going to be disposed of, then lawsuit, then it can be lawsuit.
my lord, let the matter be disposed. This very short campus, my lord. I will just show that how the government is acting. First of all, my lord, this requisition itself is not maintainable because the state has no locus. When the Honorable Single Judge, after considering all the facts, hearing both the parties, have passed an order that there is a deemed acceptance of my resignation because of the the manner in which it has been denied.
There is an order of 12/3/2024.
Lawsuit.
There is a order of 12th of March 2024
Lawsuit.
directing you to produce the records.
Yes, that
So what has happened to his resignation? Why it has not been accepted?
here lawsuit.
So you first tell us, please, then we'll see the record.
Hello. Here lawsuit, the form of instructions I have received.
My lord, on the last occasion, I made a submission, my lord. There is a third force working against me, my lord. And because of that third force, my lord, since I do not have any specific materials, I could not make a pleading, my lord. And my instruction for my learned junior is that there is a third force working against me so that I do not get the acceptance of my resignation from the government. Because there is absolutely no reason why the government should file an appeal and challenge this order. And, my lord, the vigilance clearance which was earlier issued to me was cancelled on the basis of a, my lord, complaint made by somebody. And there is, assuming there is a private dispute in respect of a land, my lord, the government has got no allegation against me about encroachment of on any government land. That being the position, my lord, the withdrawal of the and cancellation of the NOC was itself improper.
Lordship, may I explain, Lordship? Here, if Lordship turn to next page, this is second page. Resignations dated 8 September 2022, Lordship. Lordship, if Lordship turn to third page, Lordship. The Deputy Commissioner. And fourth page is the Lordship vigilance clearance certificate issued by the Deputy Commissioner, Lordship. If Lordship see these two certificate laws, NOC and the vigilance clearance certificate laws, this is dated Lordship 5th September, Lordship. Prior to Lordship, this case, Lordship, the petitioner, Lordship, he obtained these two certificates from the Deputy Commissioner prior to his resignation, Lordship. Along with these two certificates, Lordship, this resignation was submitted, Lordship. Though it's dated on 18 September 2023, Lordship, but it was submitted on 11 September, Lordship. It's admitted on in pleadings also, Lordship, in the writ petition, Lordship. What happened, Lordship? After, Lordship, this has been submitted, Lordship. Then this so far this NOC and vigilance clearance certificate is concerned. Because there is a case, encroachment case pending against this writ petitioner. And if Lordship turn to the next page, fifth page, Lordship, it was cancelled, Lordship. It was cancelled on, Lordship. It was cancelled on 18, immediately after, Lordship, around 15 days, Lordship. 13 days. Within 13 days, Lordship, this certificate issued by the Deputy Commissioner cancelled, Lordship. Then, Lordship,
Is this
the
order
petition.
under challenge 18 September 2020? Has this order?
Yes, it was challenged before this court by Dole petition number 489 of 2023, Lordship. And that was pending before this court, Lordship. Matter was of judice. Lordship, this directing the Deputy Commission to hear the parties private order within a period of 2 months, Lordship. And during that pendency, when this process was pending before the Deputy Commissioner, then the present writ petition was filed, directing that resignation may be considered, Lordship. And in that writ petition, Lordship, so far this direction is concerned that 489/2023, Lordship. That was suppressed, Lordship. That was not there in the writ petition, even not in as a pleaded, Lordship. Then, Lordship, where, Lordship, this impugned order has been passed, Lordship, against which, Lordship, we are petition pendency. This
Yeah, should there be a stay?
what the Lordship. So are the principle of law, the principle. In the present case, Lordship, whether the resignation has to be considered unilaterally or bilaterally, Lordship, that Lordship, the governing rules will Lordship decide, Lordship. In the present case, Lordship,
That's all right, but on what ground you are challenging the judgment of the learned single judge?
here, Lordship,
Hmm.
then kindly come to Lordship, read appeal, Lordship.
Yes.
Page, impugn order is at page 11, Lordship. It
Yes.
starts from page 11. I'm taking Lordship to the page 16, Lordship. Page 16, paragraph 10, Lordship.
Yes.
The Honorable Supreme Court, in case of Dinesh Chandra Sangma and others reported so and so, has been held in the context of voluntary retirement under FR 56C has held that non-acceptance of such proposal within the established period would amount to deemed acceptance on expiry of the said period, Lordship. Lordship, the law laid down in this Dinesh Chandra Sangma, Lordship, it has been applied in the present case law, where it's not applicable at all, Lordship. And this Fundamental Rules 56C, this Dinesh Chandra Sangma case it was held in 1977, Lordship. Subsequently, in year 80, Lordship, this FR 56 has been omitted by way of an amendment, Lord. Ceases rules. She is no more there, Lordship. And this is of the voluntary retirement, and it is in the context of the Fundamental Rules 56C, Lordship, whereby serving 3 months notice, one can resign from the Lordship service. But in the present case, Lordship, my senior partner has already taken Lordship to the guidelines, Lordship, rules, Lordship. Where Lordship, acceptance of the Lordship resignation is necessary by the authority. Now, what Learned Single Bench has held, Lordship, it's been deemed accepted, Lordship, from the day when resignation, from the date of resignation, Lordship, which is, Lordship, stranger to the rules governing the resignations in the previous.
Why are you not accepting his resignation? You're right.
Lordship.
You're right. The observations in para 13 may not be in accordance with law. That
Therefore, my submission, had it been the direction by the Learned Single Bench, Lordship, directing authority, you consider the resignation within the time frame. To that extent, Lordship, no problem. But the Learned Single Bench has substituted the Lordship authority. That's my Lordship grievances before this division bench. Now, as of now, also, if direction is given, there's no issue. Time frame may be given, Lordship. The authority will consider, Lordship, as per the prevailing rule, Lordship.
yes.
There's
Mr.
limited
Majumdar,
Lordship, area, Lordship.
what is your response? See, the observation in para 13 prima facie is not sustainable.
Absolutely correct. Well, my submission before Lordship will be
The principle applicable for acceptance for 56 is different from resignation. That we agree with Mr. Tucker.
My submission will be if the judgment and order passed by the Honorable Single Judge is otherwise sustainable, these small things in the judgment, my lord, Lordship may kindly ignore and see whether the judgment as a whole is correct or not. I just point out
No, it is not correct. It is not correct. There can't be a deemed acceptance of resignation. There is no such provision in the rule.
My lord, I accept for this sake of argument at the moment, my lord. I just point out two things, my lord. Lordship may kindly turn to page 45 for a moment, my lord. Page 45 of my writ appeal. Of their writ appeal. Page 45.
So, Mr. Majumdar,
My lord.
we'll turn to page 45.
My lord.
But please understand one thing. The learned single judge has said it is a case of deemed acceptance. We are not in agreement. We are not in agreement with that finding.
My lord, Lordship,
Yes,
Lordship,
there could be a mandamus, as he is saying.
my lord.
Please listen, Mr. Majumdar. As it is very inconvenient hearing matters through VC where there is a lag.
Yes,
And then if you do not have patience, then it will be very difficult, even more difficult. Concept of deemed acceptance of resignation has to be accepted or rejected. That order has to be, to that extent, a mandamus can lie, directing the authorities to take a decision either ways. But there is no question of deemed acceptance of resignation. No rule is there to our knowledge. If there is something, please point out. Resignation, it is applicable only in case of voluntary itself. Within 2 months, if it is not rejected, then acceptance. There are judgments of the Supreme Court of the Guwahati High Court on that. That analogy cannot apply in this case. So that being judgment cannot be implemented. How do we stay this order? Vacate the stay order. If you want, we can dispose of the on your resignation application today. What relief can be granted? Tell us. This judgment cannot be implemented. We cannot allow it.
My lord, I have got two submissions. Your lordship permit me, my lord.
This is wrong legal.
My lord, I have
I
got two
hope you are understanding the point list. Voluntary retirement cannot be equated with resignation. There is no question of de-acceptance of resignation. No such principle of law exists. So this judgment being passed on that principle, how do we accept the court to vacate this stay order and facilitate implementation of this judgment? How do you do that? Of course, we do appreciate that your client has a right to early answer to his application for or his resignation. That we appreciate. But that should have been the order asked for from the learned single judge. Whether resignation should be accepted or not, it is always for the authorities to decide. It cannot be the decision of the court. If the authorities do not decide in a fair and transparent manner, then mandamus can be issued, compelling them to do what is statutorily prescribed. But that cannot be substituted by the court. The court cannot say that, all right, you did not accept, we will accept it. That can't be the. What is your answer we are asking?
My lord, if your lordship permit
If
me,
you
I'll
want
make.
the entire matter to be disposed of. Yes.
My lord, I have got two submissions
Yes,
to me.
please.
Lordship, may kindly turn to page 45 for a moment. In the
Just a minute.
my lord. You see?
Provided the person must be about 50 years, he must have spent so many years in careers. If it is accepted, then the that is
Better. এটা রেডি করা রেডি করা সব ক্যারেক্টার রেডি করেছে প্লিজ
that the direction should yes. Yes.
Well, lordship will give me just a couple of minutes. I'll satisfy your lordship. What is my prayer before lordship, madam?
Yes, please.
My lord, by referring to page 45, I want to point out before your lordship that in the earlier petition, my lord, in paragraph 9 at page 45, this honorable court directed that in the matter of, my lord, this objection which somebody has filed against me for vigilance clearance, my lord, the decision has to be taken within 60 days by allowing the person who is objecting a right to place his matters. And this order was passed by this Honorable Court on 7th of December 2023. What the authority has done within 2 months? Absolutely nothing. They have done nothing, my lord. They are keeping just sitting over it so that the time for filing nomination paper expires. This is my first submission, my lord.
Yes.
Have your lordship got my lord? Page 45, para 9. This is the direction in the earlier round of litigation concerning the NOC, my lord. Page 45, my lord.
Yes.
So when the Honorable Court specifically directed that you do whatever you do, you dispose of the objection within 60 days, they have done nothing. This is my first submission. And my lord,
They have done nothing but you have another
no, my lord, filing
Mr.
a
Majumdar.
repetition. My lord, my filing a repetition is on a different context. My lord, I'm coming to that. Lordship, just my
When
lordship, my lordship will give
impugn
me
order
just
was
couple of
passed, Lord, judgment was passed. 2 months was not yet over, Lord. So question of content does not.
My lord, my filing of a repetition by
Yes.
me did not prevent them from going ahead with the compliance of the earlier order. Why, how they are taking this plea, my lord, I don't know. Who prevented them from going ahead with the compliance of the earlier order, although the repetition was filed subsequently? My lord, my submissions are very clear, my lord. There are 3 ways in which my resignation could be withheld. One, if there is any order of my lord disciplinary proceeding against me, that is not there. Any vigilance clearance against me, that is not there. So far as NOC is concerned, my lord, I'll show one more thing, my lord. Lordship will kindly turn to page 49. This is the order of 25th of February 2020, whereby the government of Arunachal Pradesh has framed the guideline as to how to proceed with the vigilance clearance. And page 49 down below, kindly see, my lord. Vigilance clearance shall be denied on the following. Number 1, if NOC from the concerned Deputy Commissioner are not enclosed pertaining to non-encroachment of government land. My lord, there is absolutely no case of encroachment of government land against me by the government. When there is a private dispute in respect of a land between 2 persons, me and another person, my lord, that cannot be treated to be, my lord. There are hundreds of cases where a person encroaches another private person's land. How come the government comes in? He has filed an application that his land is being encroached. There, the government has taken an opportunity to see that it is treated to be an encroachment on government land. There is no government. There is a specific act, state act there, my lord, for eviction of a person from unauthorized occupation of a government land. No proceeding is pending against me. In that view of the matter, my lord, the Honorable Single Judge has come to a specific finding that there is no valid reason for withholding the acceptance of my resignation. My lord, on that, my lord, I'll rely on 2 paragraphs of 2 judgments. Lord will kindly permit me to read these 2 paragraphs, my lord. 2004 2 SCC, page 150, my lord, I given a book list also I have given, my lord.
Mr.
2004
Majumdar, you
2
argue,
SCC.
but unless you answer our question, the order will be as we indicated. You can argue for the whole day. We are asking you a
My lord,
full question.
my lord, your lordship.
Single judge's order is based on a principle which is incorrect. How do we allow this principle order to be implemented by vacating the stay order? That's the simple question we are asking you.
My lord,
Either you show us that there is a provision of deemed acceptance of resignation, or else we can't. Then the entire writ appeal has to be heard.
My lord, all that I am
Writ
saying
appeal
is,
has to be heard.
my lord, all that, my lord, I am on the disposal of the writ appeal itself because there is nothing else to be heard. But my learned friend has
Understand
argued.
your client's difficulty.
My lord. My lord, what I am saying is,
Understand
my
and
lord,
appreciate your client's
Lord,
difficulty.
my lord, lordship, my lord, time
But
is
this
running
has been
out. Lordship.
created since the last 4 months.
My lord, lordship will permit me to submit my resignation nomination paper, and lordship may hear it on any date if your lordship doesn't want to dispose of the matter 2 days. My lord, my prayer is very simple. If your lordship finds there is
So
one
what is
or
the
two
last date of submission of nomination? What is the last date?
27th, my lord. This
27th of March.
March, my lord.
We will hear the writ appeal. You can
My lord,
argue
if your
today.
lordship, yes, my lord, I'm
You can
arguing the
argue.
writ appeal. I'm absolutely ready. I'm arguing the whole writ appeal today itself.
Yes, but we are not prepared to hear it on VC, Mr. Majumdar. It is inconvenient for us. So you make a choice. If you want to argue it day after tomorrow, we can fix it.
Yeah.
Writ appeal.
All right, day after
Yes.
tomorrow.
Yes. You come prepared then.
Fine.
Writ appeal.
My lord.
So and so for the applicant, so and so for the respondent. What do you call it? After hearing the submissions of learned counsel for the parties addressed in connection with the IA, we are of the opinion that instead of hearing the interlocutory application, the writ appeal itself deserves to be disposed of expeditiously. Since Mr. Majumdar submits that his client has been prevented from submitting nomination Lok Sabha elections, operation of the
Assembly.
interim order.
Assembly.
Assembly election. Assembly.
Assembly election.
Assembly election. Due to operation of the interim order in this case, we deem it appropriate to fix the writ appeal for final hearing on day after tomorrow. Give the details.
My.
Parties to come prepared accordingly. Mr. Majumdar, it's very, very inconvenient.
I'm sorry.
Half of
I'm
your
sorry, madam.
arguments have not been heard.
Yes, madam. I'm
But
sorry for that.
you have to.
I'll physically appear, madam, day after
Fine.
tomorrow.
Yes.
Lordship,
If there is no provision of deemed acceptance, then this order cannot sustain. And unfortunately, you are faced with this prospect. There is no
Right.
provision of deemed acceptance of resignation. And that is the whole basis. Of course, there was a mandamus. Then you should have waited for 60 days. You again rush to the court. That is what has created the problem. Yes. IA be kept pending.
And records may be retained, madam. My lord, Lordship may in the meantime
Record which?
My Lordship may kindly
Yes,
call for
please.
the record of My Lordship may kindly call for the record of the earlier petition, that is
Records be retained by Mr. Tapit.
Lordship, I have already produced.
Yes.
My lord, I am
Yes,
praying
he
that
has
the
already
record
got the records.
No, my lord, record of the earlier petition 489 of 2022, which was disposed of, my lord.
For that, from registry, it is to be called
From registry, my lord.
if required.
Registry to take the records of WPC
489.
number. What is the number?
489. 489.
489.
2023.
489 of Swenson. Disposed of 12/2023, is it?
My
7/12.
For which service written?
Lordship, may continue.
To continue till the next date.
Lordship.
Yes, day after tomorrow.
Lordship.
We'll
Obliged.
take up the writ appeal,
My
Close.
lord,
not the IA.
my
Yes.
deeply obliged.
You can take back. You can take back. Yes. Yes.
May please, Your Lordship. I deeply apologize, Your Lordship. This matter was endorsed to my friend Jeet Ado, additional PP, Your Lordship. However, this morning he had met with an accident, and therefore he could not come to the court, Your Lordship. If I may pray that this matter be adjourned for today, Your Lordship.
You are appearing for the appellant.
I'm the amicus curiae in
You're
this
the
case.
amicus.
Yes.
Who was met with an accident?
The
The
additional
PP.
PP, Jeet Ado, Your Lordship.
Oh. And what did you file? Adjournment? Take down, when this matter was called up, we are informed that the additional public prosecutor for Arunachal Pradesh appearing in this case has suffered an accident, motor accident.
No, Your Lordship, he just fell down from the stair, Your
Suffered
Lordship.
an accident. He is not in a position to come to the court today to conduct the hearing of this appeal. Under
Your
the
Honor,
circumstances-
if I may, I was also asked to give a memorandum of agreement that I'm
under
with
the
one citation.
circumstances, a prayer for adjournment of hearing of this appeal has been made. Considering the ground on which the prayer is made, the same stands allowed. This is again after 10 days. The legal argument. The note on written submission of Ms. S.B. Dharan, learned amicus curiae is taken on record. Keep it on record.
Next stage.
Is it written argument or grounds of appeal?
No, written argument.
Written argument.
Yes. I would prefer a fixed date, Your Honor,
After 10 days?
after 10
Is
days.
there a DD after 10 days?
Oh, wow. 2nd of April. correct. 2nd of April. correct. 2nd of April.
Item number 5.
My pleasure, Lordship.
Yes, please. Yes, Ms. Daniel.
Lordship, I'm submitting the list of dates. The respondent was the petitioner in the before the single judge. The issue was that there was a conduct of recruitment process for the post of LDC in Siang district. Then thereafter,
You are
The-
the respondent number 6.
yeah, Lordship, yes,
His appointment has been set aside.
yes, Lordship,
Correction to appoint your client. I know.
his
appoint the
client.
other side.
his
Yes.
client, Lordship. After the appointment was met, they filed an RTI after more than a year, to be precise, 1 year and 4 months. And from that RTI, they learned that the return marks of the petitioner there was, yes, there was in fact an abnormal increase of 68 marks. 68 marks, Lordship. And if your Lordship will compare the rest of the candidates' mark with the earlier marks and the second, I would say second marks, it is exactly the same, except for the petitioner. Now, Lordship, in that, because I'm also a candidate, I'm not privy to whatever is happening inside that recruitment process. If there is any lacuna, if there is any bad thing, Lordship, then my plea before the learned single judge was that such an abnormal increase in marks could not have been possible without a process of evaluation, without something fishy going there. So therefore, an inquiry should also be conducted. The learned single judge, basing on the affidavit filed by the government, because the government had admitted that there must have been some lacuna in the recruitment process and all, basing on only on that, without seeing any records, passed the order, apparently saying that in view of the higher marks obtained by her, my appointment is to be cancelled. That is the case, Lordship. Now, after this writ appeal was filed, I was taken aback actually, because I didn't expect such a huge discrepancy there. So I also filed an RTI seeking all the answer scripts, not only of myself, all the answer scripts of all the candidates, including the petitioner. They constituted a board, the authorities constituted a board, video film, broke the log and found that all the answer scripts of the candidates are there, original answer scripts, except for the petitioners. So this must be a peculiar case in which the petitioner ought to be the respondent and the respondent ought to be the petitioner, Lordship. So since this honorable court, as I read court, has exceeding powers, not only of, sorry, wrong word. Yes, extraordinary powers. It's a court of equity. So my
prayer is that such a peculiar situation would not have arisen if all the records were seen. And this calls for an inquiry as to how the recruitment process took. In fact, I tried making a complaint to the police also, which they have not received, Lordship. Now I'll come to the facts, Lordship. Lordship may see the list of
Alright,
dates.
before you come to the facts.
Yes.
Your client is out of job
Yes,
and he has been appointed.
yes.
When was the appointment made?
Appointment, Lordship. I'm not sure after.
You don't know when your client was appointed.
Not exactly. After the judgment, my lord.
After the judgment, Lordship.
That is around what time?
The judgment, my lord, was on 23/5/2022. Thereafter.
Now, before we go to the facts, can you please point out which part of the judgment of the learned single judge, according to you, is not correct?
Lordship may see. Given that the government's affidavit had admitted, I mean, it is not, it is no one that such kind of judgment has been delivered.
Alright,
Lordship.
let us do a little bit of workshop here.
Yes,
You are challenging an order,
yes,
judgment of the court.
yes.
First of all, you tell us what is your submission? What are your submissions?
My submission is, Lordship, when in such a situation, Lordship, when there is an abnormal,
That's not called submission.
Lordship,
What is your submission as a counsel? You are in an appeal.
yes.
What is your submission?
My prayer for inquiry should have been, that was in my affidavit in opposition, Lordship. That should have been considered. The learned single judge hastened to pass this order without even looking into the records. In such a situation, when there is an abnormal increase of marks, they're also only of the petitioner and not of anybody else, Lordship.
Okay, let me
Yes.
clarify.
Yes.
Submission means the reasons for which the order should be set aside.
Yes,
That's
Lordship.
called submission.
Yes, Lordship.
Particulars are something else.
Yes,
These
Lordship.
are the grounds.
Yes.
So therefore, we are asking you again, what are your submissions? You may have one, you may have two, you may have five, you may have 10 submissions,
Yes.
but you have to first tell us what is your submission. Submissions are expression of reasons for setting aside the judgment of the single judge. You have to start with that
Yes.
so that we know how to hear the matter.
Yes,
Is
Lordship.
it not?
Yes.
In an appeal, we don't start from facts.
Yes.
In writ petition, we start from facts.
Yes.
In appeal, we start from what is wrong in the judgment.
Yes.
Then if we are convinced that your submission or is or are worth judicial review,
Yes.
then we'll go into the findings and then understand the finding in the light. Starting from the other end, which you can't. You have to start from the right end, which
Yes.
is what are your submissions?
Yes, Lordship.
Tell us what is your submission. And that is because you are not arguing the writ petition, you are arguing the appeal.
Lordship.
If you are arguing the writ petition, then you start from the facts.
Yes, Lordship.
If you are arguing appeal, you have to start from the judgment. That's how counsels are supposed to argue before the court. That's why we are telling you. Because as judges, we also need a procedure to follow so that we can come to the conclusion quickly.
Lordship.
So what are your submissions?
Lordship may see my grounds of appeal, Lordship.
The grounds are supporting features of submission. What is your
Lordship.
submission?
My submission, Lordship, as I have already stated, Lordship, is that the learned single judge.
See, I'll give you an example.
Yes.
We normally don't do it, but I'll do it. Submission is the judgment is perverse.
Yes.
The submission is judgment violates the mandate of section so and so act.
Yes.
Submission is the judgment is violative of principles of natural justice.
Yes.
These are called submissions. All right.
Yes,
Then
Lordship.
the ground is, it is perverse because it has failed to take note of these materials available on record.
Yes.
That is called perverse.
Yes.
These are when you come to the grounds.
Yes, Lordship.
And then you go to the facts, saying what has happened, who was appointed, when was appointed, you have to make arguments in a court of law in this fashion. So what is your submission?
Lordship, considering that even on the face of the record,
Hmm.
considering that even on the face of the records, there were certain discrepancies. The learned, which I will point out later, the learned single judge could not have come to this conclusion that it is a plain case of simple irregularity, Lordship. Number one is the abnormal increase in marks. Number two is, Lordship, they have enclosed their mark sheets, sorry, answer sheets, Lordship. The paper of general English and general knowledge, the instructions are that you have to encircle the answers. You have to encircle the answers. That they have not done. That part also this learned single judge did not notice, Lordship. That, Lordship, to simply come to a conclusion that I have obtained lesser marks as compared to her, that there must have been some foul play.
You want an inquiry to be conducted.
Yes, Lordship.
That can't be ordered in a writ appeal. Because this writ appeal arises out of his petition.
Yes,
You have to
Lordship.
file a fresh writ petition for that. You can't get.
Other than that, Lordship, the additional affidavit which I have filed, their simple case is that there was an increase in marks based on maybe some records. We don't know. Some RTI that RTI reply, whichever had come, it should have come from the records. Now, when I filed the RTI application after this case was filed, appeal was filed, the authorities say the answer script original is not there. From where they have come to that conclusion? Petitioners. Yes. I have filed an additional affidavit to that effect. When I filed the RTI, because I was also shocked at such a result. So I filed an RTI. Then they, like I stated earlier, they conducted, there was a board was constituted. They broke the law. Video filming was done. Then they found that all the candidates' answer scripts are there except for the petitioner.
So from where
that RTI application, from where that RTI reply came, because it has to come from some records, Lordship.
Mr. Tappe, you are appearing?
Yes.
What do you have to say on this? The answer scripts are not available.
So for the particular petitioner, petitioners.
But the learned single judge has recorded a finding that petitioners scored higher marks than the.
That is based only on the RTI reply, Lordship.
RTI reply.
Since the actual records.
RTI reply was conditional and our epidemic also has come with whatever finding that is correct. Where losing the marks of the read petitioner was higher than the private student who is applicant here. So accordingly, in our epidemic also we have taken that mistake.
No, but she's asking if you lost the answer script, then where from did you give this reply?
That was not lost at that point of time. That was available at that point of time. That is why it has fallen on road. If this is a case, my lord, he will have to file a writ petition. When I obtained the answer sheet, it was available on record. I can show. In fact, I have filed a reply. If it has got lost subsequently, I don't know, somebody has to benefit from that. It can't be me. I was not in the office.
That is why I say inquiry, Lordship.
Yes, I'd like to point out one thing. RTA was punished long time back. And so far this judgment is concerned the issue. It was passed on 23 May 2022. And this court proceeding by which lawsuit is a very open box of open. It was on 5th July 2022. After the judgment, RTA was punished prior to the
2018.
I believe there was a death point time.
That's correct, but the RTI was reply was given on what basis? Where is the RTI reply?
My lord, My lord, may I also receive a few documents, my lord? Kindly a
No,
page
just
60.
a minute, Mr. Pai. Let us finish. Where is the RTI reply? Where is the RTI reply?
My RTI reply, Lordship.
No, the petitioner's marks.
The petitioner's mark, Lordship.
Yes.
Page 70.
No, Lordship, page 70 is of the page 64 is the earlier marks, page 64. Then Lordship, page 686, Lordship.
Page 64.
Lord, yes, page 64 is the earlier marks. There are two Lordship.
Just a minute. Let's go one by one.
Yes.
Page
No,
70.
that is the second RTI. There were two RTIs, Lordship. The first sorry, three RTIs.
Let's go one by
Uh,
one. Yes, what
The
is there?
first one is page, the covering letter
What
is
is
page
there in
60.
page 64?
Page 64 is the earlier marks, Lordship.
Hmm.
This is page 64,
This is
Lordship,
LDC,
Messi LDC result.
Hmm.
Messi the marks. Number 1, Mumtalo. Number 2, Najing Pari. Number 3, Osi Kopak. Osi Kopak was the read petitioner. Then number 4, Soni Jomnyang. Number 5, Gagam Moyong. This is the appellant. Now, Lordship may see page 86, Lordship.
Page 86.
Yes. In case of the petitioner, therein, Lordship, the written marks scored earlier was 214. Now, the second mark sheet, which she has obtained from the RTI, is at page 86. Lordship may see the first one, Lordship, Osi Kopak. Now, the total marks are 282. So, there's a difference of 68 marks, Lordship. 282. Then, Lordship, regarding the rest of the candidates, that is Gagam Moyong, Najing Pari, Mumtalo, Sonia Jomnyang, it is exactly the same as page 64, the earlier marks, Lordship.
So Osi Kopak is the read petitioner.
Yes, Lordship.
And where is your client's serial number?
My client serial number in page 64 is the last one.
Yes. And page 86.
Page 86 is the second one, Lordship. 202 marks. Earlier also, it was 202 marks. It is only in case of Osi Kopak that there is an increase in these marks. Also, the records, which
both them, he is higher than your client.
Lordship. No, Lordship, including the Viva marks and all, I was declared successful. Yes, this is only the written marks. He is claiming higher marks only of the written marks, Lordship. Then, Lordship,
Yes.
this page, the answer script, Lordship, which is starting at page 71, Lordship. This is the answer script of the petitioner, which he had obtained to the RTA according to him.
Page 71.
71. This is of mathematics.
Yes.
This I'm not going into the merits, what answer is right, wrong. This I'm not going. But Lordship may see the page, Lordship may see 1 or 2 pages of that, page 73 onwards. Lordship will see that the answers are encircled. the answers are answered. This is as per the instruction of the authorities of the exam. Now, Lordship may see page 76. This is the paper answer script of general English and general knowledge. Now, Lordship may see not a single one is been encircled. This is as per instruction 5 of the same page, Lordship. Mark the option neatly by encircling it in case of confusion due to incorrect marking. Option, no marks in case of any confusion due to incorrect marking of option, no marks shall be given. Now, Lordship may see from this page 77 onwards, none of the answers have been encircled, Lordship. Now, since he's basing on
But
this,
then it has been tick marked.
Lordship will see the instructions, Lordship. Page 77 only, Lordship, serial number 5. 77, serial number 5. Mark the option neatly by encircling it. In case of any confusion due to incorrect marking of option, no marks shall be given. Lordship may see the records from our other answer scripts also. All of our question answers will be encircled, except for her, Lordship. And there is a reason why this has been this instruction has been given, because, for example, Lordship may see question number 5 on page 77 itself. There are 2 tick marks. One may be of the invigilator, one may be of the candidate. How will one know whether which one is the correct answer, Lordship? The same is in serial number 5 also, 11 also. Then next page, 23, 29,
8 also.
34. Lordship?
8 also, 9 also.
Yes. So many of these are there, Lordship. So this is the reason why they are asked to encircle, and no mark shall be given unless it's correctly marked, Lordship. Now, Lordship, I am very sure, because all of us have done that exam, Lordship. All of us have encircled it. Hers is the only answer script that is different. Hers is the only marks that there has been abnormal increase. Now, Lordship, this was before the learned single judge, Lordship, this answer script. This ought to have, at least this ought to have been seen, Lordship. Only basing on the flimsy, I would say very flimsy, thin material of the learned, of the government advocate or government affidavit, saying that something might have been wrong somewhere. Only on basing on that, the learned single judge, without calling for the records, pass this in order, Lordship. Now, Lordship, had records been called, these things would have been cleared, Lordship. That is why I'm, Lordship, time and again I'm saying, since the writ petition, Lordship, I have been in the writ petition also, I have been stating that inquiry should be done in this case.
First and foremost, this encircling part, it was not even a ground in the writ petition. Maybe this is why the did not take note of it.
No, but are you aware there is a recent judgment of the division bench of the Guwahati High Court,
Well,
very recent, about 2 to 3 weeks back, where it has been held that no marks unless the answers are given by following the instructions to be.
That is there, but this was my writ petition, my lord. Nobody challenged my assertion. This was my writ petition. I came before this honorable court saying I had obtained more marks. And it is not a case of my marks was increased when I was so from here.
No, if it was required to be encircled and your client is tick mark, that is 0. That will go completely.
But the examiner has told the student to give me marks based on the tick mark, my lord. The instruction was, it should be clear that the answers are correct or not. They have done it. The answers are correct.
All right.
It is nobody's case, my lord, that because of this ground, my marks should have been 0. It was my writ petition. I came before your lordships. Then, my lord, sometime in, my lord, November, I believe, 2016, the person came to a conclusion. He was appointed on 2nd of December 2016. Then, my lord, will kindly have the next page. Before he was appointed, page 63, my lord. My lord, kindly have a
He
look.
means you're talking about?
No, my lord, this was not shown. Page 63.
Yes. Yes.
This is 7th of February 2017.
Mhm.
This is a reply to my husband. I sought the answer scripts of all the candidates. Please find where with the documents sought by you regarding recruitment of UDC, LDC, and MTS under District Administration Siang District. It will also be pertinent to inform you that the information sought by you by serial number such and such regarding the answer sheets of the qualified candidates for Viva Voce in the call letter of Viva Voce would not be furnished to you from our side, as the same documents have not been submitted to us from the concerned branch dealing with the matter. This is immediately after the results were declared. The answer sheets were not furnished to me, including mine. And they furnished this wrong information at page 64, whereby marks were shown to be 235 or 232.46. This is just a chart.
Yes.
Then, my lord, at page 66, I submit another RTI application. This is on 8/2/2017. Immediately after the furnishing of the first information, I seek only my answer script. Page 66. The reply to that is at page 68. With reference to the subject cited above regarding the answer script of Ms. Osi Kopak in written exam, I would like to inform you that we are not able to furnish information sought by you, as the same information has not been submitted from the competent authority dealing with the matter to us. My answer script was also not furnished. This was on 8th of March 2017. I have made a categorical statement in the petition. The third application was filed only after the incumbent deputy commissioner, under whose watch the examination selection process was held, was transferred. I submitted another application, madam, at paragraph 13. Then I submit this application at page 69 again. This is after his transfer. This is 2018. Covering letter, my lord, will find at page 70. This is signed by the extra assistant commissioner cum PIO, Deputy Commissioner's Office, Pangen, 10th of October 2018. Then they furnished this answer sheets, my answer sheets. Thereafter only, the my lord will see each and every page of the documents that were furnished to me. Sign and seal of the assistant public information officer is there. Each and every page, meaning there was a document at that point of time was there when the petition was filed. None of these grounds that has now been raised in the writ appeal was before the single judge. This is how I came to know what is the marks I have obtained. I was earlier not furnished. No answer sheet. How can the answer sheet not be available in new district, my lord? If something has happened, it was the benefit of the appellant. That was my case in the petition. How can, my lord, at the appellate stage now, my lord, all these years, 2022, 16 to 2022, he was serving. If anybody had access to anything, it was him, man. If there is an inquiry to be made, let him file a writ petition, right? Make a complaint first, then let him file a writ petition seeking that. At that point of time, my lord will see every page is authenticated by the assistant public information officer, each and every page. Everything is there. Right from page number 71 to each and every page is sign seal is there, right up to, my lord. In fact, my lord will see at page 86 the result.
So why this discrepancy in the marks, page 86 and then?
That is what I am
86?
saying. They did not furnish me the accurate script. And they gave me a chart, my lord, giving me wrong information, my lord. That was my case. My lord will see the forwarding letter. They deny the answer script. Then they furnish the statement. So statement of marks, page 63, my lord, will kindly have a look first. The information sought by you as serial number 2 and 4 regarding the answer sheets of the qualified candidates would not be furnished to you from our side. The same documents have not been submitted to us. And this chart was submitted at page 64. 64 is a part of 63. Only 64 has been shown to your lordships. So as on 10/10/2018, the documents was there. My answer sheet was there in the office. So how can my lord, at least in a writ appellate stage, my lord, can interpret in such circumstances, my lord? Every document, every page, in fact, my lord, is authenticated by the Eastern Public Proceedings Information Officer. In such a situation, my lord, can the writ appellate court, my lord, interfere with the judgment of Daniel Single Judge, who on the basis of records, all this, my lord, encircling and all, that was not even in the affidavit, my lord. I can show that. I can read the whole affidavit of the private respondent. Nothing was there. Two times answer sheets, my lord, were not furnished to me. In fact, I have stated in paragraph 13.
No, but finally you got the answer sheet.
Yes, that is after the deputy commissioner was transferred. Under whose watch, my lord, the selection process was held. In a categorical case. And the affidavit of the government have admitted it. It was based on records. Now, if the answer script has been lost, it is not on me, my lord. How can I be made to suffer? If something has happened, something must have happened if it has been lost now. But it is not a case for interstate, my lord, in this respect of this judgment. It is a case for another proceeding. My lord, the seen answers, each and every page authenticated by the API. Meaning thereby, the originals were there, the certified copies were furnished to me. Now in 2022, after the, and one more thing, my lord, if your lordship called for the earlier proceedings record, they took years to find the affidavit because there nothing is there. Ultimately, they had to file. The government hesitated. It must have been based on records, man. This is the case. And all these things, my lord, that my lord was submitting and submitting, it was my repetition, my lord. It was not his repetition saying that the answer script should have been encircled and so 0 marks should have been given to him, to me. That was not in nobody's case. I furnished it. It was my document. I brought before his honorable court. Now, marks obtained, calculation, I get more marks. Yes.
For this missing of original records.
I cannot be held responsible.
I don't know. That is clear. So, for debt lawsuit, because RTA was punished prior to debt lawsuit opening of the box by the constituting and portals. So, I believe debt lawsuit, RTA was correctly punished prior to that. And if you see the supporting, if lawsuit see the page 76, 71, page 71, it's the unfit of the lead petitioner who is the private respondent here. Here, this is the answer sheet of mathematics. Here, lawsuit got 98 out of 100 in mathematics. Page 71. And it lawsuit page lawsuit 76 lawsuit. This is the answer of English and GK law. Here, the Aussie Copper obtained 184 lawsuit. 184 lawsuit. And this is supported by this very answer. These are the marks given in the answer sheet. If one lawsuit 98 and 184 lawsuit, these two are lawsuit if any lawsuit, then it comes to lawsuit
I have made a chart, the questions.
288. Then kindly come to page lawsuit 86. Here lawsuit, this is the lawsuit for marks based on the marks or based on the answer sheets given in the marks given in the answer sheet. If lawsuit see the page 86, the marks obtained by Osikopa, this is serial number 1.
This is also under RTI.
RTA.
Yes.
Second
Authenticated.
RTI.
Third RTI. 2 times not furnished. third RTI after the transfer of the deputy commissioner.
Basing on this, the writ petition was filed. Here, Lordship, the serial number one, Lordship, GK, English and GK 84 and mathematics 98 Lordship. This is supported by the answer script, Lordship, which I have also referred to.
So earlier two occasions, the answer script was not furnished.
No.
The third time, answer script
Answer
along with
script was
this.
furnished.
I made a categorical statement in paragraph 13 of the writ petition. I filed the third RTI after the transfer of the deputy commissioner under whose watch the selection process was conducted.
Para,
13, my lord.
it is in page.
It is in page, my lord, 41.
Yes.
24/8/2018, he was transferred. Thereafter, I filed the third time.
And the total mark 282. And if Lordship see the serial number 2, it's Gago Moyong, who is the appellant here and private responding in the writ petition. Here, Lordship, in English and GK Lordship, she obtained Lordship 130 and in mathematics 72 Lordship. If these two are plus Lordship, it comes to 202 only, which is much lesser than the mark obtained by the writ petition. So these, so far these answers of the Gaga Moyong, the region appellant, in original is with me.
Original of answer script.
Answer script of the appellant also. And this 130 and 72.
So original of the answer script shows that total mark obtained by Gagam Mayong is 202.
20.
We are not disputing that, Lordship.
Just a minute.
Sorry.
20. And here Lordship, admittedly Lordship, on records which are supported by the Lordship answer script, the marks Lordship of the writ petition is much higher than the Lordship. Unfortunately, at this point of time, when the second RTI was the information furnished, the lesser mark was from Lordship. Yes, my friend was very unfortunate. On
So first RTI petitioner was shown lesser mark, but no answer scripts given.
No, only a
Second
chart.
only
RTI
the,
also
only the chart was given.
no RTI. Third RTI along with tabulation answer scripts were also given.
For
And if the answer scripts are looked into, then the petitioner has higher mark.
higher.
But the original answer scripts are missing.
Original
Now-
answer script of the
now missing.
now
Now, in filing the reply to the original affidavit, we have brought it on record. Because this is a certified copy of the original answer script.
and,
Authenticated by the public information officer.
and correctness of this Lordship,
It has-
the correctness of this was the RTI information and all that it was not issue. It was not the issue. Therefore, Lordship, in our affidavit, we endorsed
Let us see the record original marks of appellant.
yellow motions. In English and GK, she got 130. In mathematics, 72 marks.
Yes, anything you want to say?
Just to be very clear, Lordship, I am not,
If you want an inquiry, then you have to file a petition, not a
Lordship.
writ appeal. Writ appeal is arising out of his writ petition.
Lordship, they are saying time and again that the answer scripts of the petitioner are now lost, Lordship. We don't know when it was lost, or we don't know if the original was ever
Then you
there.
ask for the
Lordship.
information from when it was lost,
Lordship,
how they get this, that you have to ask for this information,
Lordship.
not by filing a writ appeal.
Lordship, read appeal because the grounds on which the writ petition was allowed, Lordship, that is the of higher marks. That ground itself is now suspicious, Lordship.
It is suspicious, it's not wrong.
Lordship.
See, to say that pass an order on a ground which is suspicious
Yes,
is one thing.
yes,
And to say that set aside the finding of the single judge,
yes.
because he should have suspected the ground before passing the judgment are two different.
No, no, Lordship. What I'm saying is he should have called for the records, Lordship.
Call for the records of what?
Call for the records of the recruitment process, Lordship.
So they said the month. See,
Lordship.
whatever records were placed before the single judge,
Yes.
which included the,
And the grounds which he's saying that I'm bringing now, that is because at that point of time, even I did know there's such a thing.
then you seek
Yes,
a review
Lordship.
of this order,
Yes,
seek a review of this order. See, you have to go by the correct procedure, no? Either you seek a review of the order. If
Lordship.
you want an inquiry, then you file a writ petition or bring materials before the court to show that there is something seriously wrong. Merely because creating a suspicion helps your cause, that cannot be a ground to set aside the order of a single judge.
No, Lordship. What I'm saying is that if they furnish the RTI, it is to be based on records. Where are the records, Lordship? The records are not there even now.
I'm saying it is lost now. Show something, place something.
They have never said it was lost, Lordship. There is nowhere in the record. There is just a verbal submission, Lordship.
All right, now, do you want to prefer a review against the judgment of single judge?
I'm hopelessly barred by time,
That's okay.
Lordship.
That's okay. That we can observe.
Yes, Lordship.
That
Yes.
you are permitted. What ground you want to take? In the review, what new ground?
That subsequently these things were discovered, which was
Which thing was discovered?
that the ground on which, like I said earlier, the ground on which the writ petition was allowed,
Hmm.
that was groundless. That I did not know at that point of time.
No, that's right. So
Yes.
you want to prefer a review by bringing on record subsequent.
The subsequent RTI, which I have filed,
Where is it?
additional affidavit, Lordship.
What is the date of the additional affidavit?
Additional affidavit. It was filed on August, 10th of August, 22. This is I have brought on record the subsequent RTI which I have met.
Yes.
Lordship may see annexure 1 is the covering letter. What I have asked Lordship, my RTI application, which I have asked Lordship, page 6, number A, serial number 3, particulars of information, number 3A, copy of computer test oblique typewriting of 5 candidates
Yes,
of
and where is the
LDC.
reply? Where is the reply?
Reply is Lordship, next page, the covering letter. Then page 8 is the details, furnishing of details required. Then Lordship may see this is dated 7 July 22. Saying that with reference to the above, I am forwarding the detailed information as sought by the applicants regarding to RTI Act in connection with the recruitment exam 2016 are as follows. A copy of computer test typing writing of 5 candidates of LDC were not found. So now computer typing test was also mandatory, which is that is also not found. Then a copy of a result sheet of computer test was not found. However, physical marks were seen in the computer, copy in Xerox enclosed. A copy of written answer script of mathematics, English, and GK of 4 candidates of LDC except Miss Osikopak were found in the office. A copy of relevant file oblique noting of exam were also not found. Copy of name of address and of examination in charge oblique selection board oblique constitution of selection committee of
You are reading from which page?
page
number?
8 of the additional affidavit.
Hmm.
I filed 2 additional affidavits, Lordship. The first one, Lordship, which was filed in August 22.
Then there is another one, 5th of July.
23,
the
Lordship.
Board proceeding, annexure 4.
Yes, this is the board proceeding. Pursuant to my RT application, this
So
board,
now, see, these documents are not before the learned civil judge.
yes, Lordship.
So therefore, we can't set aside the order on these documents.
Yes,
If you want to prefer a review, it is your choice.
yes.
Then we can allow you to do that with liberty to prefer a application for delay confirmation. There, they can't have anything.
Lordship make an observation because now I'm hopelessly barred by limit
No,
time.
review, there's no, you explain the delay because you preferred and read. So
Yes.
say that. That is up to her. Yes. We can't. Yes.
Otherwise, I thought extraordinary cases, that calls for extraordinary measures, Lordship.
Oh. She will withdraw with liberty to file review application. That's all. All right.
Oblige.
The writ petition would have been better. In fact.
Oh, sorry.
The writ petition, if an auditor file a writ petition.
You
that
meet
would have
him in
been
the
better,
chamber
but-
for some advice.
I'll
But don't charge her extraordinary. She is already very petrified with the term extraordinary and exceeding.
I would have thought this code is next only to God, so would
All
go
right,
for it.
anyway, see, these arguments that you're trying to make
Yes,
may appeal to you because you are the counsel, but you have to have a basis for these arguments. Otherwise, we cannot set aside a judgment passed by the single judge. If these are appeals in principle,
Lordship.
it cannot be done.
Also, Lordship, the person who had given the third RTI is the same person who had filed the flimsy affidavit in opposition, Lordship. That is,
Judgment and order dated. It is detailed the judgment and order dated 23/5/2022, passed by the learned single judge in WPC number 597/2018, whereby the appointment of the writ appellant in the post of LDC was set aside with a direction to appoint the writ petitioner oblique respond number, your respond number? One herein in the same post, comma, has been put under challenge on numerous grounds. However, while addressing argument, Ms. N. Dangeng, learned counsel for the appellant, has primarily assailed the order of the learned single judge by referring to RTI replies dated 7/7/2022. RTI reply dated 7/7/2022, which goes to show that the answer scripts of the writ petitioner stroke respond number 7 was missing. Respond number 1 was missing. First up, since the basis of challenge to the judgment and order dated so and so is the ground that there is no, no, you're right. Since the challenge to the judgment and order dated so and so is primarily made on the ground that the answer scripts of the writ petitioner stroke respond number 1 having gone missing, there is a suspicious circumstance surrounding the RTI replies furnished to the writ petitioner and placed before this court. Ms. Dangeng has played for setting aside the impugned judgment and for ordering an inquiry into circumstances of the case. First up, after hearing her submissions, we are of the view since these documents were never produced before the learned single judge, no order can be passed on those documents at this stage. First up, responding to the above, Ms. Dangeng seeks leave of this court to withdraw this writ appeal with liberty to file review petition by bringing the subsequent facts oblique documents on the record of the court seeking review of the order dated so and so. First up, the learned counsel, however, seeks an observation from this court for condoning the delay in preferring the review petition. First up, the above prayer made by the learned counsel for the appellant has not been seriously objected by Mr. Learned counsel for the respondent number 1 and Mr. S. Tapin, learned senior government advocate, Arunachal Pradesh, appearing for the other respondents. First up, in view of the above, this writ appeal stands disposed of on withdrawal with liberty as prayed for. The appellant may prefer separate application for condonation of delay by furnishing sufficient reason if so advised.
Obliged.
I'll take back the reports, please. Take the reports.
Item number 6.
Yes. Why are you preferring appeal against these matters? Jagjit Singh, Uma Devi. Yesterday also there was an appeal also, similar.
The Pina Devi also. Here also, if also see the impugn judgment law. Here the writ petition law. Few of them also they are the computer operator contingency law, and few of them are the LDC, Lord Clerk Division, and few of them are the peon law. This is a multitasking. Here lawship in the writ petition law, 3 issues were framed lawship by the learned single bench. If lawship see the issue is in page 31 lawship, page 31.
This served for more than 20 years, 21 years.
Only legal issue which I am going
The
to
court
read.
only says they are entitled to minimum pay scale. That's all.
That is their lawsuit, but whether they are entitled for that or not, so whether their case is covered by the existing case or not, only that aspect lawsuit. What I am submitting is lawsuit. The nature of work, quality, quantity, and the lawsuit, the responsibilities that they are performing lawsuit. Whether they are equally they are doing that with that of the lawsuit regular staff or not. That aspect has not been considered by the learned single bench.
No,
Because-
that is not required. If they are working against casual or contingency workers,
Lawsuit.
then these are all equitable measures as a welfare state.
Lawsuit.
There is no order for regularizing their service. But the order is that they should still be given the minimum of pay scale
Correct.
till retirement.
Correct.
And have you seen the judgment in Upendas versus State of Assam? Mr. Apang, Sajin, are you aware of the judgment? Upendas, State of Assam versus Upendas. See, the similar problem was there in that case. And the state government said, sorry, due to Uma Devi, the one-time exception is over. Now we can't regularize the services. So then the court inquired that, all right, don't regularize, but pay them the minimum pay scale. Don't terminate their services till the age of retirement. And give them minimum medical facilities so that having served for so long, if you suddenly throw them out, that will be very, very inequitable. The government agreed and that order was passed. Have you seen the judgment?
No, sir, I have not. I'm sorry, no, sir.
Why don't you see, this is just equal pay for equal work. That's the principle that they have served for so long. Forget the equal pay for equal work. Even otherwise, as employees who have been serving, look at the human aspect of it.
No, sir.
These people now have family, they have children, they have to support. How can you keep someone for contingency worker for so long? Suddenly, he doesn't even know tomorrow morning his job can be terminated. These are the
Lordship,
practical
Lordship,
issues.
so far, Lordship, these wages are concerned, Lordship. We have our own policy, Lordship. According to their length of Lordship service, Lordship. Some are given Lordship 15,000, 17,000, up to 19,000 Lordship also. This depend on the length of service. If the government has policy for the Lordship, this contingency stuff. There's another aspect, Lordship. What my simple, because if Lordship see the judgment passed by the London Single Bench, here Lordship, relying on the principle laid down in the Jagdish Singh's case, Lordship, that this judgment has passed. Now my appeal before this now called, whether the case of the petitioner Lordship, this writ petition Lordship, it's covered by the Lordship, the Jagdish Singh case or not. That only has to be seen, Lordship.
All right.
Here, Lordship, my humble submission is this, Lordship. Those aspect, Lordship, whether they are doing the equal works or not, that aspect has not been touched by the London Single Bench, Lordship. Because there is a precondition, Lordship, to avail this principle of the equal pay for equal works, Lordship. To that limited Lordship,
All right.
area.
Please. Yes. You have got the Jagdish Singh judgment? Can you bring it?
I've given the. Yes. Since it's on law, Lordship. So may I take, Lordship, the Jagdish Singh case itself,
Yes,
Lordship?
please. Yeah.
71 S.
Yes.
Here, Lordship, various citations passed by us. Honorable Apex Court has been cited, Lordship. Examination
What is the page number?
page, Lordship, it starts from page 148, Lordship. 148. It starts from 148, Lordship.
Yes.
After considering the various so many judgments passed by the Honorable Apex Court in connection to this Lordship on the principle equal pay for equal work, that's two part. One is for the Lordship regular employees, and other one is for the contingency and the temporary. Both cases have been covered, Lordship.
So what is the facts? What are the facts? Your submission is that Jagdish Singh's judgment has been wrongly applied.
Here, Lordship, the principle, Lordship, that has been determined by the Honorable Supreme Court, Lordship. Here, as I have submitted, Lordship, the nature of work, quality, quantity, and responsibilities attached to that particular post, and the qualification. These are the Lordship precondition laws. If they are equal on these laws, then Lordship.
That's what. So you are saying the principles in Jagdish Singh has been wrongly applied in this case by the London Single Judge.
No, what I'm thinking out, Lordship. This aspect, Lordship, whether they are equally, Lordship, performing the duties or not, that aspect has not been considered by the London Single Bench, Lordship. Without considering that, Lordship, this very principle has been applied. That's my submission. Why, Lordship? If Lordship,
So what are these 7 petitioners? They are working as what? There are 7 writ petitioners.
Lordship,
They are working as what?
they, Lordship, if Lordship say, petitioner number 1, Lordship, he is working as a typist, Lordship, this LDC, Lordship, typist. 2 is the Lordship peon, Lordship, contingency peon. 3 is the Lordship contingency typist again. The 4 is Lordship computer operator, then Lordship LDC, then Lordship typist, then Lordship computer operator. These are the Lordship computer
They are all working as contingency work.
contingency worker, Lordship.
Fixed pay.
Uh,
Fixed pay.
Lordship, I think they have been Lordship with that enhanced Lordship policy of the state government.
So London Single Judge said that all of them should be given the same pay.
London Single Bench Lordship directed to the corresponding Lordship, regular Lordship, employee Lordship, that pay scale, minimum pay scale be their Lordship. Lordship, the issue number 3.
So the petitioner number 1 is to be given the minimum pay scale of typist.
Typist.
petitioner number 2 is to be given minimum pay scale of peons,
beyond
like that.
like it. And so far as computer operator is concerned, also. In our statement laws, in our affidavit, we have taken a categorical stand laws that there is no post of regular post of the computer operator in the department laws. Those aspects has not been considered laws. And just I'll read the lawsuit. Just I'll read lawsuit one way. The answering response begs to state that the engagement of casual oblique contingency employees are made only for work which is casual and which is not full-time in nature. They are interested to do the minimum amount of work with lesser responsibility. So far as casual and oblique employees working at office is concerned. Paragraph 7. The answer is so and so. There is no post of regular computer operator created in the department. Hence, such regular post does not exist. As far as the post of regular LDC is concerned, appointment of regulations are made in accordance with provisions under the relevant recruitment rule. There is a provision in the recruitment rule of LDC that 15% of vacancies are to be recruited through limited departmental competitive examinations from among the skilled contingency of casual employees. The said vacancy had already been filled up by the department as illustrated down below. Then paragraph 9 lawsuit. Here lawsuit paragraph last paragraph we have stated the lawsuit. There is no shortage of UDC oblique LDC and B where the petition has been filed. The nature of duty is to help the regular staff, not engage oblique employee instead of the regular staff. They have not dealt any file as done by the regular staff. Hence, it is false to claim that they are perform the same duty and same work of regular LDC lawsuit. These are the lawsuits taken by the government in our affidavit. So my limited submission is that lawsuit. This aspect has not been considered. Without considering this aspect lawsuit, the learned single lawsuit
So what is the operative part of the judgment? Let us see.
judgment kindly come to page. It starts from page lawsuit 20 lawsuit 20.
Page,
Page 2020. It starts from page 20.
yes. Come to the operative part.
Lawsuit. Lawsuit, paragraph 28, page 46 lawsuit. Paragraph 28 lawsuit. Now, adverting to the particularity of the case in hand, I find that some of the petitioners have been discharging their duties in their present position like a regular employee for more than 20 years. The petitioner number 1 so and so has been working as ad hoc LDC since so and so, and she was appointed and so and so. The lawsuit, how they are working, it has been. Though Mr. Abang, the land counsel for the petition, submits that the petitioner have been rendering services like regular LDC, except the petitioner number 1, rest could not submit any document proof to substance such contention. Thus, it is apparent that some of the petitioners have been rendering their services in the print for more than 20 years. Even the last, it is the petition number 8 also render services for more than 15 years. As submitted so and so service required for regulation. There is no immediate prospect of regulations of their services. As presently, there is no such post for regulation as submitted by so and so, the learned so and so. As discussed above, opposite contentions of the petition have not been disputed by the respondent. Having considered above and also having considered the submission of learned advocates of both sides, and also drawing premises from the propositions of law, so in the case of Judges Singh so and so, this court is of the considered opinion that the petitioner are entitled at least minimum scale of pay in their present position based on the principle of equal pay for equal work. Accordingly, it is provided that the state government state respondents shall provide minimum pay scale to the petitioners from the date of filing of the present rate that's with effect from so and so. Lawsuit, this is the lawsuit direction given by the learned single bench lawsuit. And if lawsuit see the Jagdish Singh's case lawsuit, paragraph.
Actually, there is no direction to regularize their service.
Here lawsuit in writ petition for regularization lawsuit, and as well as in option prayer is the lawsuit equal pay for equal work. So for a prayer for regularization is concerned, that has been declined lawsuit. In the because three issues have been framed lawsuit as I said.
That prayer was not accepted.
Not
Regularization.
that has been
Not-
declined.
It was not accepted, Lordship. So we,
No appeal preferred against that.
we also did not, because now at the worst of retirement, we did not have any option. And last night also, they came and said that in case worst of the situation, we'll have to go to the Supreme Court. They say, we surrender because we are contingency peon, for last 20 years. We don't have the appropriate field. That was the thing. So we did not appeal that, but they will be happy even if they are given the lowest pay scale as given to the respondents. They will four respondents.
So why don't you give them the minimum pay scale till they are on the verge of retirement? Give them the minimum pay scale. Don't regularize them. No equal pay. We'll modify the order.
Lawsuit, here lawsuit, as I've submitted lawsuit, my limited lawsuit, ground is a lawsuit that because the order passed by the court of law, it's remain as a resident lawsuit.
No. The
Here-
court simply said that there are people working as LDC.
Lawsuit.
These people, some of them are also working as LDC,
Lawsuit.
but they are temporary.
Temporary.
So the court says that equal pay for equal work.
Equal
That
work.
you may be correct,
Lawsuit.
because a temporary employee, contingency employee cannot get the scale of a regular employee. That you may be correct. But the problem is the prayer for regularization was, I thought that prayer was the basic prayer, but that was not given and they have accepted it.
Lordship, here the private respondents were here. In the appeal, they are not before us.
Mr. Appan, you have to understand one thing.
Lordship.
Your best prayer was not granted and you accepted it. The prayer that has been granted cannot be sustained. It can't be. He is right on that. This is the wrong application of the principle. He is right. Because contingency and and regular permanent employee,
No,
even
sir.
if they do the same work, they can't get the same pay.
Lordship,
It is not equal for equal work.
Lordship,
When same category of employees do equal work, then equal pay for equal work. Their seniority has to be same, their nature of appointment has to be same, everything has to be same.
Lordship.
Otherwise, in every department, there are two kinds of LDC. One is a senior LDC, one is a junior. They are doing the same work, but the pay will be different. So equal pay for equal pay will come into play when everything else is equal.
Lordship, here the cause and the ground was that private respondents, they were junior to us when they were here at Itanagar. Same department. Now, on pick and choose basis, they have been taken to from one zone to from Itanagar to Namsai. There, in the close interview, they have been given the higher pay matrix. That was a challenge. In our, we say, first we submitted a representation saying that we also should be considered. That was not done.
But they
Then,
were regular employees.
no, Lordship. We were working together here at Itanagar under the same department. They were much more junior to us to the extent of 7 to 8 years.
Who are those people? Have you
Private respondents, Lordship. These
Yeah.
private respondents, they are not before us in the appeal. In appeal, they are not before us. In region, it was
So private respondent number 7 and 8.
Lordship,
5, 6, 7 and 8. Is it?
yes, Lordship.
5, 6, 7 and 8, they are also contingency workers.
Lordship, they are from the another lordship, John lordship. They are lordship, eastern and western lordship. Read petitions are from the western John lordship. And the private respondents from eastern John lordship. The as
So
per
the read petitioners are simply seeking parity of pay with reference to 5, 6, 7 and 8.
no. In the pleading lawsuit, that's not there. In the pleading lawsuit, they are because these private respondents are not the regular staff law. In pleading the read petition lawsuit, they are seeking lawsuit parity with the regular staff law.
Where is it? Let us see.
Kindly come to page 59 also.
Page 59.
No, sir. This is a part of read petition. Read petition is from lawsuit page 49. From page 49.
Actually, they have challenged the appointment of the private respondents.
No, they are even challenge the appointment of private. Kindly see the paragraph 8 also. In paragraph 8 also they admitted lawsuit. So far when past contingency is appointed lawsuit. Hardly lawsuit 10 or 11,000 is lawsuit paid. Here lawsuit the petitioner are getting from 15 to 17,000 per month. Because they have served lawsuit for longer period.
Paragraph 8.
Paragraph 8.
So, Apang, you file an appeal. Otherwise, you are put clients into great difficulty. See, we are always conscious about justice, but we have to deliver justice in accordance with law. Prayer and the writ petition is in one direction. The single judge has passed an order in another direction. The state is challenging. We'll have to set aside the order.
Lordship, we were following the principles of beggars cannot be choosers.
Sorry?
Beggars cannot be choosers.
No, it's not about beggars or choosers. See, if your clients cannot afford, we have legal aid councils.
Lordship,
Just
that is
filing an appeal is, you're appearing in this case also.
even I almost
File an appeal, we'll hear it together, no?
Lordship.
Then we can mold some relief for your clients.
Lordship, accept that. I'm accepting that, Lordship. But on top of that, Lordship, here is a case wherein, Lordship, now, of course, that will come if it's in the I think appeal, Lordship. That is the Lordship. Now, staff selection board was created, and the post which these private respondents were holding, it was only for 1 year. 2021, still they are continuing. Staff selection board is functioning. Many exams were held. This has not been placed. And they were our juniors. They were taken from Itanagar to Namsai. And Namsai also, since they are working in the chief engineer's office, only those employees were taken for DPC. No advertisement. And more so, we have filed another additional affidavit wherein many were appointed as ad hoc contingency. Within this Itanagar, there are 6 after us, and they are also getting more than 22,000 plus. Now, these are the system going on with the department. Now, at the time of filing this petition, those records were not with us. On filing RTI, we got it. And more so, now there are, as per staff selection board, there is a recruitment rules. And as per that recruitment rules, some percentages are there for direct recruitees, some percentages are there for contingency staffs. Now, that also has been not followed. And of course, today I have brought,
Mr. Apang,
Lordship,
we would like to ask the government, why aren't you not regularizing or considering their cases for regularization?
Lordship.
You are stopping us, your clients are stopping us from asking that. If you do not file an appeal, you made a prayer, the license just did not give it. You are accepting that. So all roads are closed for your clients unless you challenge that order. Equal pay question doesn't arise, that he is right. But then it is also equally true that having served for 22 years, where will these people go if the government does not give them some kind of a, we are in a welfare state. So
Lordship.
whatever be the policy cannot be anti-people. So if you have allowed these people to work for 20 years, 21 years, you have to give some minimum protection. But you are not asking for that. Equal pay for equal work you will get.
Lordship,
That is a wrong judgment.
Lordship, our equal pay for equal work is with those private respondents. Private respondents, Lordship, may please be pleased to turn page 111, Lordship. Here, Miss Kabilai, daughter of so-and-so, who is working as casual computer operator.
You press your prayer for regularization, Mr. Apang. I think
Lordship.
that will be better. You just need to file an appeal. We'll hear both the appeals together. Because if it was a tender matter, we would have simply washed our hands off. But we are conscious that these people are facing a lot of difficulties.
Lordship, may I have the liberty to have a discussion with my clients? So let the matter be posted some other day, Lordship.
When do you want it?
After a week.
All right, heard Mr. Estafil, senior government advocate appearing for the appellant. Also heard Mr. Apang, senior counsel appearing for the respondents. On the request of Mr. Apang, this hearing of these matters stands adjourned for a week so as to enable him to obtain updated instruction from his client. Mr. Apang, just for your benefit, your client's benefit. You see, regularization is the basic prayer. If you give that up, you get nothing in this case.
Lordship.
Be very sure about it. Even if we uphold this order, state is going to go to wherever in appellate forum. And this will be a meaningless exercise.
Lordship.
Only thing you can ask for is some kind of a normalization of your service. Forget who is getting what, who is not getting what. You first show that you are entitled to something under the law.
Lordship.
So even if there is no regulation, at least you can and read the judgment open thus. That will be helpful.
Obliged.
Yes.
Lordship, Lordship, I beg to mention item number 6 and 9. On behalf of P. Tagum, Learned Standing Counsel for the Education Department, He is out of station because of some personal difficulties. So
On the prayer made on behalf of Learned Standing Council Education Department, this matter stands adjourned for 2 weeks. 6 and 9, same.
there is more one item, item number 12 also, Lordship.
Item number
12.
12 also Education Department.
No, no, this one is another matter. This one is other matter.
You are appearing for whom?
I am appearing for respondent number 4 to 17.
I'm for the petitioner.
So he wants time. Any problem?
Yes.
On the prayer of Learned Council for the respond numbers 4 to 7 made with the consent of the opposite party. This matter stands adjourned for 3 weeks. List accordingly. Item 12. Yes.
May Lordship, I beg to mention item number 2, Lordship, on behalf of Bintar Picha, Lordship. Conducting counsel is out of station, Your Lordship. Matter may be adjourned for today and maybe list after 2 weeks, Your Lordship.
You are appearing for whom?
Respondent number 5, Your Lordship.
On the prayer of Learned Council for the respond number 5 made with the consent of the other side. Admission and hearing of this matter stands adjourned for 2 weeks. List accordingly. Yes.
And there is one more matter, Your Lordship. Item number 5, Your Lordship.
Yes.
On behalf of B. Picha for the petitioner, Lordship.
So, on the prayer of Learned Council for the petitioner made with the consent of the others, admission hearing of this matter stands adjourned for 2 weeks. List accordingly.
Obliged, Lordship.
Lordship, I beg to mention item number 17. Here I am appearing for private respondent number 7 to 17. Lordship.
What do you want?
Lordship, the matter may be fixed after 2 weeks.
On the prayer of Learned Council appearing for the respond number 7 to 17 made with the consent of the other side. This matter stands adjourned for 2 weeks. List accordingly.
There is an interim order.
Interim order passed earlier, if any passed earlier to continue till the next date. Yes.
May I please, Your Lordship? I'd like to mention WPC number 601 of 23, may be listed on 21.
May I please? Lordship, I beg to mention item number 36 to 38.
6 to
36 to 38. I have requested my senior friend also, if it can be taken up tomorrow also. Thirty-six, 37, and 38.
you are here for this week?
I'll stay back, Your Lordship.
I have it day after tomorrow then.
Day after tomorrow.
Yes. Tomorrow will not be possible. I'll fix it.
I'll stay back, whatever date you see, but I would very much like to press the hearing.
No, that's all right.
Whatever Your Lordship advises me.
What can be done? Why you want time today?
Lordship, actually, unfortunately, our records gone missing. Lordship. We are just, since yesterday, we are looking for that records. My staff is on Lordship. Now today, we are getting copy from them only to accommodate my senior Lordship.
This was an excuse made earlier also, Your Lordship. And Your Lordship may remember yesterday they were saying we have completed the, I don't know what, but I have said you can take copy from her.
Then day after tomorrow?
Left.
On the request of Mr. A. Kashyap.
And not my request, Your Lordship.
No, listen. These matters were fixed today for final hearing. However, today when the matters were called up, Mr. S. Tapping, learned senior government advocate Assam, Arunachal Pradesh, appearing for the respondent submits that the records have gone missing in his office and therefore some time be granted to trace out the relevant records. Full stop. Considering the nature of controversy involved in this writ petition and keeping in mind the urgency expressed by Mr. Kashyap in the matter, this court is inclined to grant one final opportunity to the Learned Departmental Council to trace out the record by deferring the hearing of this matter till 20th of March 2024. Register to list the case accordingly.
All right.
Yes.
Will be heard day after tomorrow.
Yes.
Lordship,
May I beg to mention item number 22, 3 to 26.
Item number
23 to 26.
23 to 26. Yes,
Hearing matter.
what do you want?
The matter may be listed after 4 weeks.
You are appearing for whom?
I'm appearing for 23 and 26. This is a take-up matter, and my friend requested me to this adjourn the matter. So they are not ready.
I'm not, one earlier also date has been fixed for day after tomorrow, but while mentioning it's 28th, 21st, it should be.
It's a 21st, 21st,
Full correction.
21st.
Item number 24,
23,
25 is
22 to
represented by
26,
other
right? On the request of Mr.
Titapak.
T. Tapam Learned Council,
All the matters.
made with the consent of the opposite party, hearing of these matters stand adjourned for 4 weeks. List accordingly. 23 to 26. Any more mention? Yes. You are appearing?
Yes, Your Worship. May I please, Your Worship?
Yes. What is the violation?
Your Worship, this contempt petition is filed.
All right. Your name,
Non-compliance.
please.
E.
Yes.
Benjo.
Heard Mr. So-and-so Learned Counsel for the petitioner alleging willful violation of the directions contained in the order dated 13/6/2023 passed by the learned single judge in WP bracket C bracket close 56/2023. This contempt case has been filed. So stop. I have perused the statements made in the petition. Stop. Issue notice returnable in 6 weeks. Petitioner to take steps for service of notice upon the sole respondent by registered post with AD within 3 days from today.
Highly obliged.
My Lordship, this matter was earlier filed, Lordship, filed in the before this honorable court, but
We have to issue notice at this stage.
yes.
All right. But Mr. T. Tapak Learned Counsel for the writ petitioners, parents the amendments made in the writ petition. The primary grievance of the petitioners is on account of alleged non-payment of compensation for the occupation of their land. Non-payment of compensation for the alleged occupation of their land by the authorities. Mr. S. Tapin, Learned Senior Government Advocate, State of Arunachal Pradesh, is present on behalf of respondent numbers. Respondent numbers 1 to 5.
Yes.
And prays for some time to seek instruction. In
Lordship,
view of the
1, 3, and 4 Lordship.
1, 3, and 4. Not Deputy Commissioner.
No, Deputy Commissioner.
One,
2 is
not
the
two.
secretary lane Lordship. They are one is standing counsel.
1, 3, and 4. Prays for some time to obtain
1,
instruction. In view of the above, issue notice of motion returnable in 4 weeks since Mr. So-and-so has accepted notice for respondent numbers 1, 3, and 4. No formal notice is required to be sent to the said respondents. Extra copies of the writ petition, requisite in numbers, be furnished to the learned government advocate for obtaining instruction. Petitioner to take steps for service
Yes,
of notice.
I have interim prayer is there. On the next date fix. Interim prayer may be heard.
Upon the remaining respondents by registered post with AD, heard on the prayer of interim relief, the said prayer will be considered on the returnable date.
May I please, my Lord? Hello, this is a transfer matter. Your
The transfer order was passed on 5/3.
5/3, my Lord, 5/3/24.
Malad, since last 1 year, I was transferred 4 times consecutively. So now even my health is also not supported. I'm getting treatment.
Yes, but
and
there
what-
is a problem. You see, now election code has come.
Yes,
So in transfer matter, unless you make the election commission a party,
Malad,
no transfer can now take place.
Yes, transfer order was passed on 5/3/2024.
It has not been implemented.
Before passing a notification of the election commission of India.
So now election commission is in control.
Malad,
You have not joined. You have not
no,
been
you're not
released.
joined, Malad.
Not yet joined.
You're not joined. And even you're not released from my present
They,
place of
they
post.
can't release you now. We'll issue notice then.
Yes, Malad.
Yes.
Malad, till then, impugn
All right, you're Mr.
N. Rama, Malad.
N. Ramanayak counsel appearing for the writ petitioner. Peruse the amendments made in the writ petition. The petitioner has challenged the transfer order dated 5/3/2024, by means of which he was transferred from the Papumpare district to the West Kamen district. Transferred, where is the order?
Transfer from West Coming district to East Coming district, SEPA.
West Kamen district.
Present
West
impugn
Kamen
transfer.
district. According to the petitioner, the transfer order dated 5/3/2024 has not yet been given effect to, and he has not been released from the present post,
Present place of posting.
present place of
Kalaktang.
posting at
Kalaktang PS, Malad. Kalaktang PS, police
Talaktang
station.
PS in West Kamen district.
Yes, West Coming.
Full stop. Since the ground for assailing the transfer order is on account of acute health problems
Yes, ma'am.
allegedly faced by the petitioner, this court is inclined to examine the matter. Full stop. Moreover, due to the coming into effect of the Model Code of Conduct, it may not be permissible for the government to take any proactive action in the matter without the approval of the ECI. Full stop. Issue notice returnable in 2 weeks. Since Mr.
Yes.
S. Tapin Naner, Senior Government Advocate, State of Arunachal Pradesh, has appeared and accepted notice for passport number 123. No formal notice is required to be sent in this case. Extra copy of the written petition, requisite in numbers, be furnished to Mr. Tapin within 2 days from today. Heard on the prayer of interim relief. Having regard to the facts and circumstances of the case, it is hereby provided that status quo as regards the place of posting of the petitioner be maintained till the next day. List this case again on 3rd of April.
Deeply obliged.
3rd April
Status
2020.
quo as on today.
Status quo as on
As
today.
on-
Status quo as on today as regards the place of posting of the petition.
Because we do not now at this
That's
stage.
not a status quo as
Yes.
on today.
No.
In any case, if he has not shifted, then you can't shift.
Yes, yes, that's the law.
All right. Yes.
Master.
Time to accommodate in some other alternate place because petitioner is a poor unemployed
How
person.
much time he needs?
So in meantime, I pray your lordship that representation filed by the
Oh, no, no. How much time he needs? We'll give you time.
6 months, your lordship, time may be given.
6 months.
Because
Yes. You can't evict him now during the
No,
election.
Lordship, their tactics is always,
So-
Lordship, after the state, they make a proper building there. They start say, this is a temporary, Lordship can see the tin set here. The
I have no money,
In
your lordship, to build the buildings. I'm poor, that's why I'm
No,
asking that.
Lordship, in the eviction notice also, they have said, stated that, Lordship.
Petitioner will, your lordship, will give undertaking before the concerned
No.
authority that he will not build any
In every case, Lordship, this is,
permanent structure or
everyone gives undertaking, and this is forest land, Lordship. It is a forest land, Lordship.
few months time, your lordship. I need to.
So what will you do after
I'm desperately, I'm searching some other places alternative, but I have a family, minor children, so I need some time. So I verbally requested the forest
So we'll give
authorities.
him
also.
4 weeks. After that, we'll see. Let him vacate within 4 weeks. He wants 4 weeks time. We'll give him 4 weeks time to vacate on his own.
Lordship, if he doesn't vacate, then Lordship interim may not be, any protection may not be given, Lordship, because in every cases, Lordship, after taking stay, they start building in.
No, that will ask him not to build. No undertaking.
And
The
this
court
is
will
not,
pass an order.
In the picture itself, it can
Petitioner
be,
has
Lordship,
never
seen.
have disputed that land belongs to him or he have not stayed there. He only seeks some time. Earlier also he have approached to give some time, but problem is here that lordship is an immediate alternative arrangement he could not make. So
No, but you see, that's okay. We understand there could be, but then you have to be reasonable.
yes,
huh?
yes. So I pray your lordship 6 weeks time may be given by
6 weeks. By 6 weeks, if you don't vacate it, they will go ahead with the eviction. We'll dispose of this writ petition.
Yes, that may be, Lordship.
Yes, heard
properly.
Mr. So-and-so learned counsel appearing for the writ petitioner. Also heard Ms. G.A.T. learned additional senior government advocate Arunachal Pradesh appearing for the official respondents. By filing this petition-
My name is your lordship, A. Bhattacharya.
A. Bhattacharya. Yes, sir. Arup Bhattacharya.
Yes.
By filing this writ petition, the eviction notice dated 5/3/2024 issued by the range forest officer to the petitioner has been put under challenge. By the impugned eviction notice, the petitioner has been asked to vacate the encroached forest land within 15 days from the date of issuance of the notice, failing which eviction would be carried out against him. Full stop. The petitioner's counsel submits that his client is not denying or disputing the fact that he is in possession of forest land, but due to his poor economic condition, the petitioner is not in a position to immediately shift to another plot of land for residence. Full stop. Mr. Bhattacharya submits that all that the petitioner is seeking from this court is 3 months time to vacate the land voluntarily after locating an alternative place of residence. Full stop. Mr. Bhattacharya further submits that his client is giving a categorical undertaking that till such time he is allowed to remain in the land, no permanent and oblique or temporary construction will be raised by the petitioner. Full stop. Ms. G.A.T. Learned G.A.P. on the other hand has submitted that similar writ petitions submitted that large number of persons encroaching forest land has approached the court by making similar prayers, but they failed to vacate the land. Ultimately, as such, the relief as prayed for by the petitioner be declined by this court. Full stop. I have considered the submissions made at the bar and have gone through the materials available on record. Full stop. It appears that the petitioner is in possession of forest land wherein he has constructed a temporary dwelling house and is residing therein. Full stop. Since the petitioner has admitted that he is in possession of forest land, the question of interfering with the impugned eviction notice dated 5/3/2024 cannot arise in the eyes of law. However, taking note of the submission of Mr. Bhattacharya that if some time is granted, his client would voluntarily and of the qualified over the plot of land in question. With the above observation, petitioner disposed of the
Obliged.
Obliged.
Item number 33 is report.
Make please.
Your responded. Your lordship, please pass over the matter. Yeah.
Huh?
Pass over the matter or something else.
Pass over.
Yes, sir.
Why?
Standing council is engaged on the High Court Court number 2.
Standing council?
Standing council is engaged on the High Court in court number 2.
Standing court.
Yeah, standing council is engaged in court number
magistrates
2.
Huh?
Standing council.
Who is standing council?
Sir, Pitam Tapo. Pitapo. Yuri.
So, all right, the petitioners start their case. Let the standing council come. This matter was, these are the two cases.
Yes, ma'am.
These are fixed items today. You tell him to come. In the
Okay,
meantime, we'll just begin. Otherwise, it will be difficult to. Yes. We call this standing council.
May I please, my lord? So, my lord, the petition.
Yes, what are you challenging? Where is the order of cancellation of LPC?
That is page 90.
Page 90.
Yes. Page 90, Annex Chapter 10. By this order, the C3 housing transfer 9.12 acres along with built-up structures and transfer in the name of Department of Housing, Government of Arunachal Pradesh. So there is so many story.
So you received 0.093 crores.
That I am not disputing. So I have entered into agreement, MOU with.
No, 1 minute. This money you received from whom?
From the company.
Huh?
Company. Respondent number 3.
Is that correct? You have paid.
My lord, in the entire amount, my lord.
Don't start argument in the entire.
No, my lord. I'm just informing, my lord.
Not.
Paid, my lord. 3.10. And rest of the amount, the Suda has paid.
Sorry, how much you paid? How much?
90.10. 93 lakhs, 10,000. Yeah, this is what.
And SUD has paid?
Yes, the rest of the amount Suda has paid, my lord.
So it was 10 lakhs and 2 lakhs record.
Not 10 lakhs, my lord. They have paid actually 20 lakh rupees to the petitioner. My lord.
20 lakhs per acre.
No, not 20 lakhs per.
The agreement.
that agreement constitutes that, my lord, the rate of the per acre rate was 10 lakh rupees per acre. my lord.
That's what I'm saying.
Yes, my lord.
10 lakhs you have to pay and 2 lakhs the SUDA is to pay.
Yes, my lord. So,
No, why do you say no?
no, I'm not saying no, my lord. I'm just informing, my lord.
Hmm. No, answer the question.
Well,
Otherwise, I will
I'm
fix
sorry,
the
my
matter after this.
I'm
If
so
you
sorry.
want, because we'll go in a straight line and finish it off.
My lord.
Don't go here and there. All right, now, you are aggrieved by this order of 3.
Yes.
Who is in possession of the land?
Land is under my possession.
Under your possession?
Yes.
Where is the document to show that?
Madam. Since page 19 is LPC, Land Possession Certificate.
Page 90.
19 on XR1 series.
Is it 19 or 90?
19.
LPC is issued by whom? The Deputy Commissioner.
Deputy Commissioner.
Under what provision?
Under Land Regulation Act, madam. But because let me come. Part I have not there. LPC, since I have a land, they approach me to give.
No, these are not important for us. We will only see who is power to do what. You don't have the where is
my books I have not. Sorry.
Then tell me when we'll fix.
Other
it.
is
We'll go ahead with the next matter. That is for appointment to arbitrator. If you are not able to defer it, is a judgment. We get a judgment on who is on there and who has come. What is the law? So who is authorized to issue a LPC? Who is authorized to cancel it? What is the procedure for cancellation? Has that procedure been followed here? These are the things you have to argue.
Yes,
Otherwise, there is nothing
yes,
to hear.
This is the competent person.
Show me.
Then in that case, my let it be tomorrow. Then I'll bring.
But he's not aware. Page number? For you to come forward. Fortune is in your
Yes.
favor. So what is to be done? You are not aware of your.
No, has to be cancelled by the day or complained by someone.
Is it that provision? Show us.
LPC.
LPC then.
No, this is separate. Under this 80 Act 2000, you know, then rule was framed in 2012. Possession certificate, you know,
Is a pro.
it is by another notification. There is a guidelines which prescribes to fill up in the form that is for hearing, then have a survey.
That's correct, but it seems he is not ready. Mr. Tafo, yes. Is the power of respond number 2 to notify transfer of ownership?
Matters, it's not like that, madam. What happened, madam? These two people, they entered into agreement.
Yes.
The agreement not with the government. They entered into agreement. He was contractor. He had entered agreement with him to construct an affordable house. And between them, there was an agreement. He will give the land, and they will. And if they execute a contract building for it has given to the people. Whether it given without the land, it should be the land. They have
Therefore, government has paid the amount was required by them for the land. After what happened, project they couldn't complete. And the people posited the amounts, filing a writ petition before this court. This court said, take the amount. And the contempt of
Government paid the money to whom?
to the beneficiaries who deposited the amount for the affordable house. It was constructed land, and the land was given between each other, the contractor and them. He doesn't have any connection with the government.
Maybe, but how can your department cancel the LPC?
No. But the impugn order was given to him, Malad, not to him.
Please.
This is my case.
Please see page 90 of the petition.
Malad, 90.
90.
No. 98 lordship.
90.
No. Malad,
so that is not to him. We'll quash it then on concession.
No, that's why, Malad. The agreement was between them. Look, he was contracted, he has taken land from him. We paid the amount.
No, and that's all right.
Yes.
Mr. Tafu, please understand the query.
Yes.
The operative part says, consequent upon making full and final payment, the possession and ownership right of the land measuring 9.12 acres, along with the built-up structure, stands transferred in the name of Department of. Oh, how can you do that?
No, but that agreement is already done, man. For execution of that project, land was already transferred, man.
Is there a tripartite agreement between the housing department, the owner of the land, and the
No. Lordship, between them, right? And because he was these lordship, the first the MOU was between them, which
have issued an order transferring the land unilaterally. You can't do that.
Yes, lordship. After the MOU with him, the land belongs to the department, man. With the building, because now standing buildings are there. Half the door. He could not complete the project.
May I allowed to speak, my lord, because I think I might clarify more.
We have paid the people who have invested for the housing project. Definitely, madam.
See, I don't know. Maybe this is a fit case to find out. This whole thing appears to be completely sham. Completely sham.
Yes.
Your understanding of law has got nothing to do with what the courts will do. How can you do something like this? A private person's land without a tripartite agreement to pay their money. Then you say, I'm taking over the land and building. This is all what?
No, madam. Tripartite, we didn't have agreement with him. He had agreement with him, and he got the land. He had agreement with us, madam, for that land.
No, but he cannot enter into an agreement with you for the land. He is not the owner of the land.
That was the agreement within us.
You sort it out with him. But this order, this is illegal order. You had an agreement with him. You take recourse against him, get the money from him, get the house from him. You did not have any agreement with the landowner. How can you have this kind of a power? Under what source of statute?
Lordship, I understand the order which has been passed, madam. The ought not to have passed in this manner. Otherwise, the land already belongs to the department, madam. This order ought not to have been passed. Whereas the land was already with the department.
Then withdraw it and pass correct order. Withdraw it.
Lordship understands when sometimes officer.
You have to set aside the order. What option do you have?
Otherwise, it's a purely matter of civil dispute, madam.
That's right. There's a civil file. How can you take over the land? The matter is before the civil court.
But the possession must be with us already.
No, this is wrong. It was never with them.
Without.
Right, you finish and we'll hear him and then pass the judgment.
Yeah.
I'm setting aside this order. It's not sustainable.
Otherwise, the grievance would be against him only, madam. The contractor.
That will see the next matter.
One agreement within them.
That is the point, Mr. Tafo.
Yeah.
How can you chip in this? Particularly when the person who is this Dishi Mihu Malo,
Yes.
she appears to have already approached the civil court. There is order of injunction. When all these things are pending without taking the leave of the court, you
But
immediately
injunction not against us, but to the other party.
whoever,
The parcel of plot of lands are totally different, but the injunction was with regard to different plot of land. Because the land which was given to us was some portions of land, not entire plot of land.
and then without issuing any notice, this order will go only on one ground, violation of principles of natural justice. That's all. How can you unilaterally pass such order? I'm taking over your position. Huh? This never happened in the medieval
That
India.
sounds that way, but otherwise, but the land was already with us.
Then why did you issue this order?
No, Bharat, what happened when we returned the amount to the depositors, Bharat? Because we said
No, you do many wrong things and then to cover it up, you do more wrong things.
No.
You want the court to-
Exactly.
therefore the officer might have thought we have issued such an order. After paying them, because government had to pay the amount to the depositors.
You recovered the amount. Recovered the amount. You have to civil suit. There is no other way out. Without civil disputes, whether you are government or whoever, same law. It's time people understood this. Government doesn't have any privilege in civil matters. They're like any other litigant. You want to take back the possession, you have to file a suit and get a decree. There's no other way out.
The land was already in our possession.
Don't disturb their possession, that's all.
Malav?
You cannot, this thing cannot be decided in a petition. The order is expressly illegal. Kind of an order cannot be passed.
From his own annexes which is annexed man. That itself shows man already transferred the land.
All right, you conclude. What else to submit, you conclude?
Therefore, what we are submitting is the agreement was between these two parties. We don't have any connection between. So land has been given by the agreement was between them. He has handed over the land for construction of building. That was the first ground matter. We have to have the land. Then only building could be constructed. So after everything, then only executable that one plot of land. The contract. So the suit in concern, he should have sued against him. Now both of them are in collusion. They have come before this.
This procedure is not correct. There are better ways of dealing with these things and the correct, that should be done.
I mean, there have been some, the order should not have been passed. I agree to that.
We'll grant you liberty to proceed in the matter in accordance with law, not beyond that. Yes, what do you have to say?
Please, my lord. My lord, in this matter, my lord, there was one agreement, my lord, respondent number 3 and the petitioner, my lord. So that agreement was, my lord, for the total land at measuring 45 acres, my lord. The first breach that petition was, they had given 9.12 acre, my lord, out of that 5 acres. And then after that 9.12 acre, they have given us for the construction. Subsequently, joint venture agreement. We approached Suda for certain permission, my lord, and Suda became the party in this matter, necessary party. So accordingly, my lord, once we sign an agreement with Suda, we started land given to us. We have already paid the amount, my lord. The agreement amounts has already been paid to him. So the consideration, once the consideration has been paid, the land, particular land, 9.12 acre has already been transferred to us, my lord. So they have nothing to do with that. And in consequence, of that, my lord, they are actually suppressing one material fact in this. And first payment that they have taken from us. My lord. Then after my lord, they have taken 20 lakh rupees from the Suda, my lord. Subsequently, my lord, they have get rupees from Party, my lord. They have not mentioned in the rate, my lord, but the document says so. So, my lord, was a person who has not this on court with the clean hands, my lord, and by suppressing the material facts, my lord, how is mental this is our. So, the first thing, my lord, they have actually extracted the money from respondent number 3, Suda, as one private party, my lord, for the same piece of land, my lord. And now they are coming before this honorable court and seeking the release of that particular area. How is possible? So far as writ petition is concerned, this is our submission, my lord.
What is the civil suit about?
My lord, we are not party to that civil suit, my lord, because basically what happened, lord, the brief background of this matter is we were given the construction, 9.0 went to us. And Suda had promised in the agreement itself, and we'll come to once the next matter will be called, my lord, then we'll definitely show him, my lord, that in that matter, so my lord, it was promised by Suda that the construction will be started once we will receive the booking, and only 100 plus booking, and they requested us to start. So, my lord, to start any that kind of construction, my lord, we had to apply so many things, my lord. So, and subsequently, my lord, the law they couldn't. They have said that they will protect us from any kind of interference in during the construction, but they didn't. We outsiders, my lord. We went there. We started construction. In fact, construction. So then after the certain goons came and just they have just throw away my laborers. They have looted all.
All right. Come to page 16, your first prayer. What is this 38, 2018?
It's 60.
Page 16, yes. This is the order date 38, 2018.
38. Oh, my lord, that was typical mistake. This is 339. It was not clear, so I couldn't.
All right, take down. Mr.
G. Tarak.
Name, please.
G. Tarak.
G. Tarak, Learning Council appearing for the writ petition. Only in item 33. Writ petition. Also heard Mr. P. Tafo, Learned Council appearing for the respondent. Mr.
Abhinav Prakash.
A. Kashyap, Learned Council, has appeared on behalf of respondent number 1.
3, my lord.
Respondent number 3. Who is for 1?
1, Mr. Pita.
Mr. Tafo for 1 and 2. Is it 1 and 2?
Yes, 1 and 2.
1 and 2.
It's for 1 and 2, my lord.
A. Kashyap for respondent number 3. First step. By filing this writ petition, the petitioner has prayed for setting aside the order dated 3/9/2018 issued by the Housing. Bracket to the government of Arunachal Pradesh, Itanagar, taking over possession and ownership rights of the land measuring 9.12 acres with built-up structure standing thereupon in favor of the Department of Housing, Government of Arunachal Pradesh. First, the facts of the case in a nutshell that the writ petitioner hearing claims to be the owner in possession in respect of a large plot of land measuring about 45 acres based on land possession certificate bracket LPCs issued by the Deputy Commissioner of Papumpare district in her favor on 11/8/2008. Is it 11/8/2008? The LPCs are annexed to the written and contains the area of the land along with proper description and boundary in respect thereof of the land claimed by the petitioner. Full stop. As the landowner, the petitioner had executed an agreement dated 17/2/2010 with the respondent number 3 for construction of 3,000 affordable houses over the aforesaid plat of land. First of, as per the agreement, the petitioner was to receive a sum of rupees 12 lakhs per acre as premium of the land, which was to be shared by the respondent number 3 and the housing department in the ratio of 10 lakhs by the petitioner, by the respondent number 3 and rupees 2 lakhs per acre by the respondent number 1. Full stop. Based on such agreement, the State Urban Development Agency bracket SUDA bracket close had entered into a separate agreement dated 03/10/10/3/10/2010 with the respondent number 3 herein for execution of the project at Lower Jolang JOLLANG bracket PAGA Paga Tarak 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 bracket close on public-private partnership model. Full stop. It appears that the construction of housing unit had also commenced and the attending purchasers had also deposited initial amount for purchasing units of the newly constructed houses. However, at that stage, a certain dispute cropped up between the petitioner and the respondent number 3, as a result of which execution of the project got derailed. Full stop. It was at that stage.
I was at that relevant point now. The abundance of disputed arises.
Some delay, some dispute arose pertaining to the execution of pertaining to the land as which the execution of the project got derailed. Full stop. Situated thus, the respondent number 1 had issued the impugned order dated 3/9/2018, the operative part of which is reproduced herein below. In page 90, double tick to double tick. Full stop. The impugned order has been essayed by the petitioner's counsel primarily on 3 grounds. Firstly, that the impugned order is without jurisdiction inasmuch as the Secretary Housing to the government of Arunachal Pradesh does not have the power and authority to cancel the LPC, nor could he unilaterally transfer the ownership and possession of the land in favor of the housing department by issuing the impugned order. Stop. Number 2, the impugned order has been issued in utter violation of the principles of natural justice. Number 3, there is no privity of contact between the housing department and the petitioner, and therefore merely based on the agreement entered into by the SUDA with the respondent number 3, no action for taking over possession of the land would have been initiated by the department. Stop. Mr. P. Taffo, London Standing Council, Housing Department has vehemently opposed the prayer made in the writ petition by contending that the plot of land was always in possession of the department and therefore the impugned order did not change the nature of title and possession of the over the land system. In fact, submit Mr. Taffo, since the department was possessing the land, the impugned order dated 3/9/2018, according to him, was a redundant exercise and ought to have been avoided by the department. Full stop. The learned departmental council has failed to address argument on the plea that the respondent number 1 did not have the power to cancel the LPC and or to take over possession of the land unilaterally, nor could he meet the grievance of the petitioner that the impugned order has been issued in violation of the principles of natural justice. Next paragraph. Mr. Kashyap, Learned Counsel, appearing for the respondent number 3, has argued that
A. Prakash.
Mr. A. Prakash, and counsel for the respondent number 3, has argued that it is the petitioner who had acted in utter violation of the contract agreement by failing to permit his client to execute the project, despite having received more than despite having received a sum of rupees 93.10 lakhs from the respondent number 3.
With the possession out of 45 agreed acres that was supposed to be handed over by the petitioner to the respondent number 3, they have had 9.12 acres.
Acted in violation of the terms of the agreement, in as much as instead of handing over possession of the entire plot of land measuring 45 acres, only an area of land measuring 9.12 acres had been handed over to his client for execution of the project, thus creating major hurdles in completion of the project as per the original DPR. The learned counsel for the respondent number 3 further submits that there is a serious contract between the petitioner and the respondent number 3, as a result of which a separate petition in arbitration petition number AP close of 2022 filed by the respondent number 3, seeking an order for appointment of arbitrator is pending disposal before this court. First of the petition having acted in contravention of the term conditions of the agreement, there is no infirmity in the action on the part of the departmental authorities in taking over possession of the plot of land in question. More so, since the petitioner had received an amount of rupees plot of land measuring 9.12 acres. More so, since the petitioner had received a sum of rupees 93.10 lakhs from his client and a amount of rupees 20 lakhs from the SUDA as agreed price of the land measuring 9.12 acres. I have considered the submissions made at the bar carefully through the materials available on record. As noted above, the plot of land measuring 45 acres appears to have been allotted to the petitioner based on LPCs issued by Deputy Commissioner of Papumpare District. First up. The no. Under the law, it is the Deputy Commissioner of the district who is the competent authority, either to issue LPC or to fill the same stuff. Mr. Tafo has not been able to invite the attention of this court to any statutory provision which permits the Secretary of Housing of the Government of Arunachal Pradesh to take over possession of the land and transfer ownership, the contravention of the LPC standing in the name of the petitioner. Moreover, it is the admitted position of fact that the impugned order dated 3/9/2018 had been any prior notice upon the petitioner. If that be so, this court is left with no manner of doubt that by the impugned order dated 3/9/2018, neither the right nor title nor the possession of the petitioner can be taken away in respect of the 45 acres of land held based on LPC issued by the Deputy Commissioner Papumpare. First up. Therefore, the impugned order dated 3/9/2018 over the writ petitioner is hereby quashed. Notwithstanding this order, it is made clear that if the departmental authorities are of the view that the petitioner has acted in a manner which is illegal and in violation of the interest of the department, it will be open for them to initiate action in accordance with law by serving prior notice to petitioner. With the above, the petition stands allowed.
One more submission I'd give this matter, my lord. If my lord can record that, my lord, my submission was that they have taken actually same piece of land. They've taken the money twice, my lord, from the two different parts.
Mr. So-and-so has father that, but these are not going to be
Not in
Actually, just for the sake of submission, my lord, because you see, my lord, because
has taken money
because my
from
lord,
two different parties with regard to the same plot of land.
Yes, my lord.
by me.
Before I say I have considered, right? The petitioner's counsel has, however, strongly refuted all allegations against her client by the learned counsel, appearing for the respondent numbers 1 and 2, as well as respondent number 3.
We have the admission of the petition, although my
No,
lord,
no, no, let's
just
not
because
admit-
my lord, I just wanted to submit because writ petition of they are not coming before this honorable in hand. This is why this submission just.
We are not very unclean and irrational principle nature.
My lord, that part is very clear.
We don't have time for all these things. You want to argue the next matter?
Yes, my lord.
Yes. What is your place?
My lord. Yeah, sure.
You're a party in this?
Yes, sir.
Why?
Yes.
Are you a party to the agreement?
My lord, I will just give
The
it
agreement,
but just
allowing
allow me 5 minutes, my lord.
No,
I'll
no,
just.
no. You first have to answer my question.
My lord.
You want appointment of an arbitrator.
My lord.
Where is the arbitrator?
My lord. My lord, that others in this matter, my lord, so far as with the
Where is the arbitration clause?
my lord, I'm coming to it. That is agreement within agreement, my lord, there is the arbitration clause, my lord.
When do you want matter to be fixed?
My lord.
When do you want the matter to be fixed next? You are not answering the question. You have to have an arbitration agreement.
My lord.
That agreement must bind both of you
My
and
lord.
have a binding arbitration clause.
My lord.
And there must be demonstration.
My lord.
If there is an agreement, there is no tripartite agreement.
I have a
The
judgment, my lord.
department
that clear, my lord, that both, that are interlinked with each other, my lord. Then sole arbitrator appointed by the court can.
But that the arbitrator will decide.
Yes, my lord, because before even my lord has power to decide, my lord. May I come with the, let me just
What
come.
is the arbitration clause?
My lord, that so far as this agreement with the Disam Malu is concerned, that is in page number 40, the writ petition that agreement is, my lord, is at page number 40, there is an arbitration clause, my lord.
Page number
That
40.
is, yes, my lord.
This is the agreement dated?
This is the agreement dated, my lord, 17 February 2010, my lord.
This is entered between?
This is in petitioner and Disam Malu.
So petitioner and the respondent number 2. Arbitration clause is clause number?
Clause number, my lord, is 27, my lord.
No, you said page number 40.
Yes, my lord. Page number 40 of the writ petition, my lord.
Writ petition is disposed of. Now we are in arbitration petition.
My lord, I'm just, my lord.
Or you the writ petition?
No, my lord. In this also, my lord, I'll come to that. So, my lord, page number 40 also is also annexed, my lord. So far as this agreement, from page 27 to 41, my lord. Is annexed to my petition. Annexed is from starting from 27, page number 27 onwards, and at page number the arbitration agreement.
Which page is the arbitration agreement? Page number
40.
40.
My
petition.
My petition.
Clause number?
27, my lord.
You see, this is page 40. Where do you see 27?
Some error. It's annexed to. Sorry, there is. Resignation ratio. I'm so sorry, my lord. Spot range. I mean this because my apologies.
Give me the arbitration conciliation. You have a bad day, you have a problem. There is no arbitration agreement. Clause 27 is not an arbitration agreement. No, it does not say that imposed by the arbitrator final and binding on the parties. That's the law. Somebody made a mistake, but it is a costly. First of all, have you understood it? The effort the court makes to make the council understand is to ensure that there is no miscarriage of justice. This is not an arbitration agreement. Where are those judgments? Supreme Court has time and again held that unless there is a clause saying that the arbitral award passed by the arbitrator will be final and binding on the parties, no arbitrator can be appointed person to serve. Are we aware of the decision? No, frankly, are you aware of that law or you are just?
But there are many, I mean, this is, my lord is very, my lord, this is a judgment. Of course, my lord, there are judgments, I mean, eight.
Constitution bill judgment.
Yes, my lord. And my lord,
Mistake.
I think, I'll take one more time, my lord. So
There is a way out if there is a waiver. If they waive it, then section 5 will help you.
Yes.
Otherwise, you have to go to the civil court.
Because, my lord,
You can argue the matter for 2 days, 3 days, but
My
that
lord,
is the ultimate. End result is this.
my lord.
You want arbitration or civil court? Dispute has to be adjudicated. Don't argue on that. Yes. I'm not hearing. Now, up to them. Okay, you are agreeable. Then they are agreeable.
My lord,
No, arbitration lordship, even if the, my lord, even if the arbitration clause was there, there's a limitation for, my lord, filing an application.
Limitation of filing which application?
Arbitration, my lord.
No, arbitration, the moment notice is.
No notice, my lord. Yes, the written letter.
They have not demanded appointment to arbitration.
Yes, of course, my lord.
Where is that letter? Does see?
Please, my lord.
The dispute, my lord, he is aware, my lord, writ petitions were being filed, my lord. He was aware of that, my lord, since 2016, my lord.
Okay. Yeah.
No,
limitation has a role.
Yes, sir.
But
in 2000, twice.
Court will not give a ruling on limitation.
No,
this has to be raised before the arbitrator.
But
civil court.
Yeah, definitely a civil court, my lord.
Where is?
Yes, ma'am. Yes, my lord.
Where is the letter demanding arbitration?
I'm coming to that. 13 December 2014.
On the page number.
Page number is election 9, my lord, because page initial somewhere in my lord is not.
Then you rectify that time.
No,
you will not be able to answer this question. I'll tell you that.
Demanded the to fund the appointment or for the arbitrator, my lord. From the department also we have written, and to the this
at all. Here we are not into what you have done, whom you have. We are not concerned.
My lord.
There are three things which has to be there. First is an arbitration act, which says the award. But then there is no, and consequently no arbitrator. The other is under section 7. If there is a written other form of agreement.
Yes.
Today we will not take matter. I will pass a final order dismissing the petition, which will not be a good idea. Please listen to the points you have to meet. Come pagination. Every other document there is a problem with pagination. I know you are an outstation counsel. Visit Arunachal again. What is the problem?
Yes.
Your clients are from Delhi.
Yes.
You are also from Delhi.
Yes.
Oh, Arunachal is a beautiful place to visit. Come again, but you must come prepared.
Malad, I'm prepared, Malad, but basically issue is this pagination, because when the council here, they have done it actually, removing objections and all that, Malad.
I understand that's not your fault, but then there is a High Court rule that it is
Yes, Malad, right.
What to do? Tell me what to do.
Malad, because
I'm sorry, Malad, there's no such letter even.
No, letter is
letter is totally different.
Where is that letter? Let us see. Which page?
In according to us, Malad, annexure 9, Malad, which is referring to page It's 19. Yeah. Page 92. Last paragraph. This is what this is not demanding arbitration.
This is not a demand for appointment of arbitrator.
Even in next annexer page annexer level.
There are letters that
Yes,
is
me,
filed dated. Okay.
Letters were there,
Letters
were not
there. We had written to them. One was on 24th of July 17, my lord. That letter part of this.
Sorry, my lord. Next speaker.
Prakash, can you please straight away come to which, according to you, is the best letter demanding appointment of arbitrator?
My lord, 26th December 2017, my lord.
Where is it? Which page?
Page 60. Resignation.
Which letter?
That is the data letter 26 December 2017.
But while conducting the hearing of this petition, it transpired that there are some defects in the pagination, as a result of which the court was not in a position to follow the submission of learned counsel for the petitioner. So, under circumstances, hearing of this matter stands deferred, permitting the petitioner's counsel to rectify the pagination. Let the matter be timely. Parties are not given a name. Who is appearing?
This matter has come for the first time, madam. This is an appeal under section 37 of
So
the.
this is not gone.
No, my lord. Here, my lord.
This has not gone by.
Appeal against an order passed by the district judge under section 9, the Arbitration and Conciliation Act. Here, my lord, what happened? The contractor, that is the respondent, he was awarded a first phase of work for construction of a building. In the meantime, while
May I
construction was.
May I speak in the
Please. I will accommodate.
Why don't you let him finish?
Will accommodate.
To go somewhere.
No.
Will accommodate.
I'm praying for adjournment. Lord. The reason is the meeting.
Let him submit.
Here, what happened? Contractor was awarded the first phase of work for construction of a building, mini secretariat at Tapology. While constructing, what happened? He claims that he's done some additional works and there has been cost escalations. Now these are the disputes he have started raising. Now work has been completed in the year 2022. Now second phase of work has come. Second phase sanction has been done for the remaining like boundary walls, which was not covered in the first phase. Now tender has been plotted. Now they approach the civil courts for compensation of monetary gain, my lord, seeking this additional money for additional works or this cost enhancement. Now, what the district judge has, section 9 has stole the second phase work. Second tender. My lord, if my comes to the impugned order, the second tender has been,
How can he do that?
my lord, that's, therefore, my
Which
impugned order.
page, which page is impugned order?
My lord, the first impugned order, the interim order has been continued. The interim order, the first interim order my lord, will find at page 31, my lord. Page 31, annexure 2. This interim order has been completed.
Actually, that is why you want time.
Now,
My lord, leading counsel is from Guwahati. That is the reason. Leading counsel is from Guwahati. So-
and they have
so that is the reason I-
made a submission that to award the work for the second tender has to be arbitrated before that, and that has been accepted. My lord, will kindly see page 31. This petition is section 9 of the Arbitration and Conciliation Act 1996 with a prayer to stay of the fighting tender for so and so issued by the so and so. The brief case of the petitioner is that for the same work, ENIT was plotted in the year 2015 by the same authority by ENIT dated so and so, in which the petitioner has participated and work was duly awarded to petitioner by offer letter dated so and so. However, because of delay in awarding work, the execution of the work was also delayed, for which revised estimate has to be submitted along with bills of work, which was not part of the initial contract order. There is an additional fund for the other additional works are yet to be, because of some dispute on the bills between the parties. However, the respondent on inspection of the constructed building has a letter to the petitioner for handing over the building, letter dated 28/1/2020, which was replied by the petitioner by his letter 2/2023 with a request for clearance of pending bill dues before handing over the building. The respondent authority, instead of clearing the bill and taking possession of the constructed, surprisingly issued the impugned e-tendering notice in their website. They are inviting tender for the same work.
Right, Mr. Atul, you may have a justifiable point. This order excessively appears to be unsustainable, but staying this order would amount to allowing the appeal. So we'll have to give him a limited.
Yes, my lord.
No adjournment. We'll give a fixed date after 2 weeks.
No, my lord, here what we will have to already, we'll have to surrender because it's a ending, my lord. My lord, friend, Mr. Nair has requested to take up the matter day after tomorrow. My lord.
Yeah, after
Friday.
Yes,
On Friday.
no, I have, he was saying initially for Friday. It will be too long, but I also have to. Day after tomorrow.
Day after tomorrow.
Day after tomorrow, my lord.
Day after.
Mr. Council appearing for the. Also heard Mr.
K. Bui.
K.
Bui.
Bui. K. Bui, Council caveator sole respondent. The caveator respondents who seeks posting of this matter again on 21st of March 2024 on the ground that his senior, who is an outstation counsel, will be present on that day. Since the appellant is praying for a party, is praying for a ad interim order of stay of the impugned judgment, the prayer made by the respondent's counsel is allowed, condition that no further adjournment will be sought. Register to list this case again 21-3.
Obliged.
Item number 1.
Pertains to
We are yet to receive the instruction, waiting for the instruction.
So what to do?
Yes, for your lordship.
Mr. Deepavali Land Council as appearing petitioner. Miss, your name please?
P. Sangeeta, your lordship.
P.
Sangeeta.
Government advocate P submits that instructions are stated and therefore 4 weeks further time be granted for obtaining instruction. Prayer allowed. This the matter again after 4 weeks. Interim or past earlier to continue.
Item number 4.
Mayor, Your Honor, here I have to file rejoinder.
Your name, please? Mr.
For the
Swain.
petitioner.
Huh?
For the petitioner.
Mr. Swain, with counsel for the petitioner, prays for and is granted. 2 weeks to file rejoinder.
Item
One last the state.
Item number 13.
Here, Your Honor, respondent number 3 have not yet filed their reply, Your Honor.
I'm appearing for respondent number 3, Your Lordship.